challenge
Hmm.
cognizance undated at 2021 malers offense under section 365 395
Where is the charge sheet?
maler already charge sheet has been submitted.
Where is that? Copy you have not filed.
Malers
Copy has to be filed.
copy already.
Cognizance order you are challenging. Where is the charge sheet?
Maler as per the FIR story was rod.
Sorry, I want to see charge sheet.
Charge sheet maler.
We don't know whether FIR story is correct or
Maler.
not. After investigation, something else might have come. How do you know?
Maler.
Charge sheet has you filed charge sheet.
Maler charge sheet already filed kurchu maler. Sir,
Where is that?
kurchu.
That's what I'm asking. Where is that charge sheet?
Charge sheet maler.
Yes.
Yes, maler. Maler
Yes.
sir, FIR unknown laws by the
What is the
complaint.
allegation against you? Tell me.
Minors, the place of occurrence minors present petitioner already Visakhapatnam hoche tourist minors jaitla. Place of occurrence na registered owner minors or Godam present petitioner minors. Present
I didn't
petitioner
follow exactly what is your case?
minors.
For
Minor-
passing of cognizance order, what is your
Minors.
case?
Minor present petitioner has been falsely implicated in this case. Present petitioner place of occurrence na say already minors mane occurrence notila
My
minors.
lords, if I may,
Then it is a matter of plea of alibi.
Falsely
It has to be
implicated
proved.
korai minors.
Plea of-
It has to be
plea of
proved.
alibi on the basis of that. How can we cross it? You have to establish plea of alibi.
Minor falsely implicated kori ଗୋଟେ case କରି ତାକୁ arrest
Right.
କରିକି କିନ୍ତୁ registered owner.
Maybe.
Minor kindly see Annexure 3 page 48 minor. Annexure 3 page 48. Minus we are present confirm your arrival dated 23/11/2020 and departure date
You were-
24 minors.
Right?
Visakhapatnam
You say that you were in the Novotel hotel on that day.
minors.
But this document is a private document, has to be proved.
Minor net copy minors hotel net copy minors. Hotel net copy.
Mr. Pratap will conduct.
Yes, yes. Pratap.
my lords, in any case, the FIR is dated 26/1/2020.
Hmm.
His alibi document, he says he's checked out of the hotel on 24/1/2020. So it's not even an alibi as per the face on the face of the
It is
record.
not a perfect alibi also.
My lords.
So, you raise all this point in the appropriate stage. Let the counsel for the petitioner seeks to withdraw this
Minor state,
presentation, with the liberty to raise all the points, raise all the issues before the court below at the appropriate stage. The petition is disposed of with the liberty as spread. Next. Yes. Item 2. You can.
My lord,
Yeah. Yes.
my lord, item number 2, my lord. May it please your lordship. My lord, this is a case under section 482, my lord. The petitioner before your lordship is a company engaged in the real estate business. The challenge is, my lord, to the proceeding under OPID Act, section 6 of the OPID Act. And the prosecution and the proceeding is going on before the OPID designated court at Bhubaneswar. My lord, my entire grievance is that there is already a judgment of this honorable court, wherein this honorable court said that this OPID Act is not applicable to the real estate business holders, my lord.
But that is under challenge before Supreme Court. It is pending there.
Yes, I know. I am just coming. My lord, that is under challenge before the Honorable Supreme Court. My lord, there are a bunch of cases before the Supreme Court which have been also rejected here that has been stayed. I will show to your lordship the orders, my lord.
Yes.
Your lordship kindly see my associate will hand over.
Give. Have you given it to the other side? Yes.
My lord, your lordship kindly come to this judgment, my lord, page 21. That passed by Justice S.K. Paningray.
21.
21, my lord.
Yes.
My lord,
Here, my lord, The
But
finding is,
this honorable court has held that the judgment rendered in this case has been held that it is per incurium. I will show you that the decision in Lordship called tomorrow. I have no knowledge that just
No,
this honorable court held that it is per
the
incurium.
first judgment is per incurium.
Yes,
Uh,
I will cite.
whereas this is pending before the Supreme Court.
Supreme Court, but same issue was raised.
Huh?
And this honorable court final disposed of another CRLMC, holding that the earlier decision has not been taken care of in this case. So,
Therefore,
yes, madam.
My lord,
Tomorrow, day
I
after
have
tomorrow.
one submission, my lord. My lord, I
Huh?
have one submission.
No,
my,
what he is saying is, let it come tomorrow.
Yes,
my
he will
lord,
come.
I bow down, my lord. My lord, at the same instances, all the proceedings have been stayed before the Honorable Supreme
There-
Court.
therefore-
That has to be taken into consideration.
That's right. Therefore, tomorrow I'll put it.
my lord,
let it-
it may be day after tomorrow, my lord.
Okay. Then day after tomorrow is holiday. Let it be tomorrow.
Then my lord,
Thurs-
next Monday,
Next Monday one.
Tuesday. kar-
Tuesday,
No,
next Tuesday, my lord.
Sir, what I was suggesting is let it be tomorrow after lunch. Because I have
No,
to
no.
stay the proceeding if these things have to be believed.
Yes,
no?
my
Since
Yes, my
all
lord.
the matters are pending in Supreme Court, awaiting
Yes,
the
my lord.
judgment of
Yes,
the
yes,
Supreme
my
Court,
lord,
it
yes.
is pending.
My lord,
We'll
তাহলে
pay
কালি আসু supplementary আসু, my lord, কালি।
supplement, supplement. Okay.
Aye.
You come with that. See what
After
ideally
lunch.
the issue is pending before Supreme Court. Wrong,
Yes.
right, whatever.
Yes,
Let- Till it is decided, awaiting the judgment of the Supreme Court, we will stay the proceedings.
Milord,
Yes,
then all the cases will be stayed with 50%.
So therefore you show me.
Milord.
Therefore you show me. Tomorrow.
Grateful, my lord.
Mm. Yes. Yes.
Item 6, 1 week after money. Oh, sorry, madam.
Okay. Yes.
The petitioner is the company. The case under the OPID Act, Lordships.
Yes.
Charge sheet was filed, Lordships. Under section,
Okay, what do you challenge here?
I have challenged the subsequent charge sheet filed by the another IO. On
What
this-
is wrong in it?
wrong, Lordship, to the extent that it is contradictory to section 240 as well as 20, because there is no new evidence to that effect. I'll face another trial.
Supplementary charge sheet, you need not face another trial. Same trial.
That is what, Lordship, I'm telling my, requesting my.
Yes.
At the flag end of the trial, Lordships, IO were examined, all the IOs were examined. Another IO came forward. He filed supplementary charge sheet by saying that the
Stage of trial.
stage of trial. Trial is over, almost over. I have cross-examined all the IOs. 3 IOs.
Yes, who is appearing?
Milord.
I have cross-examined
How-
all the IOs.
How will you justify that?
Another
I can understand if 173(8) is open, you can file it and put him to trial, it's different story. If one IO has investigated the offense and the trial is going on, he examined the IO, thereafter you bring another IO and start further investigation. How will you justify that?
No, Milord, in this case, several CRLMC have been filed.
Huh.
And the exact status of that CRLMC and order passed, even the direction was issued in many CRLMC to make further investigation in the case.
No.
Yes,
Is
yes.
there any direction by the court?
I will examine Milord detail. Your
No.
Lordship, Friday,
With great respect.
I'll have to stay this.
and already the interim order is there.
With great
2015
respect,
One
matter.
minute.
before this temple,
2015 matter.
Do you have a stay in this?
I am continuing with the stay.
Although you, when?
Milord, Friday I will.
16, you come.
16, chief court matter.
So how does it make one matter you will hold, you will argue what? I
I
will accommodate you to, you will get a pass.
fast ରୁ ଆସୁ First ଆସୁ ଯଦି ହେଇଗଲା ଏଠି ସରିଗଲା
Whatever, we'll accommodate it.
Fine,
Also,
let's see, let's see, let's see.
So, a very small issue.
Let's see.
It has
My
to-
lord has understood it.
it has
ଆଉ
to
ମତେ
go accordingly.
ହଁ
If they can't justify, it has to go.
let's see.
As simple as that.
Let's see.
Yes.
Interim order to continue.
Interim mode. Yes.
May I plead your lordship?
Yes.
In this case, your lordship, on last occasion, your lordship instructed the state council to take instruction whether any confiscation proceeding has been initiated or not.
Yes. This is
Regarding
557, huh?
457.
Sorry, 457.
And that 457 order has been challenged,
457 was rejected on the
rejected in the revisional forum, your lordship.
and on the ground that confiscation proceeding has already been initiated. That's
Not initiated, your lord. The provision is there.
provision may be there.
Not initiated. That is the finding, your lordship.
What is the when the matter should taken upon the coordinate bench of this court directed the state
My lord, may peruse page 36, your lordship.
whether the confiscation proceeding has already been initiated in respect of vehicle or not. Mr. Raghuda, yes. Have you read that order 2/2024 in this case?
Lordship, the revision order, the order of this honorable
Yes,
court, my
yes.
lords, we had sought for instructions, they haven't arrived yet. My lords, may give me
Yeah.
2 more weeks. I shall seek the status of the confiscation proceeding.
Lordship,
Because this is because of change of counsel or you are asking?
Lordship,
Mr.
I
Raghuda
have
appeared and he said that he would be seeking instruction.
my vehicle has been within
And
the
one
police
more week
custody.
we had given. Already.
Lordship,
My lords, then
page 36 only.
No, but this order will comply.
Both the court has rejected my application on the basis there is a provision of confiscation proceeding.
I know that is the reason the two orders were
But
passed.
confiscation proceeding has not yet been initiated. So I should not be remedialist, your lordship. And the court has ample power to release my vehicle under 457, your lordship.
Hmm.
And
Definitely.
this is, my lords, if on this point, my lords, it's not that they're remediless. There is a rule 13 which
But
says release of.
I am not on remedy list or not.
My lords.
Whether can a 457 application be rejected on the
My-
ground that a confiscation provision is there, so therefore I'll not allow. You have not initiated confiscation. That's the reason I asked whether you have initiated
My lord,
confiscation proceeding or not. If you have initiated, I can understand. If even you have not initiated, the revisional court says that since there is a provision, I will not do it. What is it?
obliged, your
My
lordship.
lords, I shall seek, my lords, may give me 1 more week's time. I have received this file
On
only yesterday's file.
21/7/23, they have
I'll
took
personally
time,
call
your
them.
lordship. 21/7/23, they took time for it.
Only 1 week because change of count.
My lords.
Mr. Raghuda is
No, man, 3 to, on 3 to date.
Last time,
Notice is
my lord,
3
senior was
to
there,
6
your
is
lord.
1 week time.
so last opportunity. By the
My
way, yeah. What is your exact name? I will
Nikhil Pratap.
Nikhil Pratap.
Nikhil Pratap. I know Pratap only. Nikhil, I don't know. Mr. Nikhil Pratap appearing for the state seeks further 1 week time to seek instruction as to whether confiscation proceeding regarding the vehicle in subject has been initiated or not. By way of last and final opportunity, 1 week is granted. List the matter on. Put it on next week. Somewhere in 21st, 23rd, so, 22nd.
My lords,
Yes.
obliged.
Without bail, huh? Yes.
Obliged.
5.
May I plead your lordship? Offense under 341, 323, 294, 307, 379 and 34 I be similar. The matter has been already settled between the parties. Informant before your lordship. Miller.
Who is that? Where is the FIR?
FIR Miller Annexure 1.
What? It is at small office. 307 is there.
307 is
What
there.
is the injury? Where is the injury report? Injury report. Injury report. He is accused.
Informant Miller.
Where is the accused?
Accused ये पास करूचनी आसुचनी गोटे
But
पास
where is the injury report? Just see whether what kind of injury.
Lordship, we have not received the CD. The injury report is not a part
You
of.
tell
the
me what
petition.
is the injury.
injury is simple in nature so far as the FIR is concerned Miller. गोटा say last
That
person
whether there was a
no
medical conducted or not. Medical report.
medical report
Charge sheet is not been filed.
charge sheet already
Then you
filed.
must be having the charge sheet copy.
Yes, my lord. Certified copy of.
Let's see. Give him the charge sheet copy. I'm passing over it. Pass over.
Ole.
Pass over. See, give the charge sheet copy,
Pass.
let him make.
Oh,
Yes.
ole.
Next. Just check, Mr. Ragada. They've settled. Is it simple injury, then we'll do it. Yes.
Item 6, my lord, next week.
Next week. Adjourn. I'm not sure next week or not, but adjourn. Best.
Item 7, pass over.
Pass over.
Item 8, my lord, challenging the order of taking cognizance under section 120B, 420, 467, 468, 465,
Okay.
406, 623,
What is the case?
294, 506, 34 of Indian Penal Code by the learned JMFCO Bhubaneswar, my lord. I have annexed annexure 4, my lord. Initially, a complaint case was filed, my lord, by the complainant by the 16 number 8071 of 22, my lord, and the same was sent to police station for registration, and same was registered as Chandaka PS case number 14 of 23, my lord.
156.3.
Yes, my lord.
Where is the
Eh.
complaint copy?
Complaint copy, annexure 1, my lord. And the same was sent to police station 156.3 of service, my lord, and thereafter investigation was conducted, and after investigation, my lord, final report was submitted, my lord.
24 affidavit there.
Instead of verification, they have written an affidavit. Okay, anyway.
No, affidavit page 24, my lord.
That stated above are true to best of.
My lord, final report was submitted. During the course of investigation of this case, I visited the spot, examined the complainant as well as the other witnesses.
What is
And
your case?
my lord, allegation is that
How, why, at this stage the court will interfere?
my lord,
Allegation may be whatever.
the police during the investigated the case, and there was no manipulation is there, my lord, and submitted final report, my lord.
Where is that finally?
Page 36, lords, may kindly glance. In the charge sheet I have annexed.
Annexure?
Annexure 2, the last portion, page 36, my lord.
This is the charge sheet.
Yes, my lord. During the course of investigation of the case, I visited the case spot, examined the complainant as well as the other witnesses, and recorded their statement on 161 CRPC, seized Khatiana from the complainant and released Jima to the seized cell deed from the sub-register office, and released the Jima, submitted detailed investigation report SCP for Bhubaneswar, and received order SCP for number ete and praised to approved. Hence, I submitted final report, returned as the FRT insufficient evidence.
Then
Thereafter, my lord, another complaint case was filed
In shape of protest petition.
in shape of protest petition, same allegation, same allegation.
But they might have brought evidence. What to do? On oath,
Same allegation.
on oath, they 200, 202 evidence they might have brought from.
222. I have everything.
The evidence copy mo paikhe nahi seta.
That's let us see what that evidence.
Yes.
They have
Yes,
taken cognizance on the protest petition.
Protest petition.
Then what are the material placed before the cognizance court? Show me. Your case is 156.3, direction was there,
Yes,
FIR was registered, investigation taken place,
Taken
final
place.
report filed.
Final report.
They filed a protest petition.
Protest petition. on
Evidence
same
was
cell.
recorded. And after evidence was recorded, cognizance is taken. Where are those evidence? Unless the court see the evidence, what material has come against you? How will I know?
Some other day, let it come.
File, let him file. Urgent. Yes. Yes.
Lord, it's a case, the entire proceeding is completely without jurisdiction. The criminal case has been under challenge, cognizance order, and that order passed on section 156.
Cognizance court has no jurisdiction or the police has no jurisdiction?
Police has no, I mean, first of all, the cognizance court, the way it has been taken has no jurisdiction. First, that's the first point. I'll rely on an order. Then secondly, your lordship will find interestingly, it's an offense under the Odisha Forest Act. Lord, against this particular complainant, there has been series of litigation, counter litigations against between themselves. Cases are there which have been finally reported, though list of cases I have given. But I am not going to those factual aspects at the present. Now, so far as this present case is concerned, the person against whom I have lots of cases in between ourselves, he suddenly makes a complaint against me that there was a sandalwood Chandan Gacha inside the temple
Against Biranchi Narayan. Biranchi Narayan gave a
against
complaint
me, against me,
Ah.
saying that there was a sandal tree inside a temple premises. By use of a vehicle, I came, I caught, I removed. Entire thing I have taken away. On that basis, case of 379 and other offences of IPC has been made out. So in my,
79.
my humble submission is, Lordship will find that sandalwood is a product which is covered under the Forest Act. There is a separate chapter for that. How the sandalwood, the Odisha Forest Act specifically.
Show me the FIR.
Right.
A final report. Rather.
It's not a FIR, it's a complaint to itself.
Complaint.
Right, my lord, kindly see.
Yes. Annexure 4.
Right, my lord.
Come to
I'm
annexure.
grateful.
Let us see the
I'll show that.
cognizance is taken. FIR is registered.
Lord, after the
156.3.
problem is, yes, after the 1cc was filed, suddenly magistrate refers the matter of 156.3 to the police. Now, police submitted the charge sheet. 156.3 should not have been.
Page 40 Satya Patha. Otherwise, otherwise also.
Police, my lord, court should not have submitted this directly to the police without an inquiry on section 202. There is a specific order passed by this honorable court. My learned friend must be knowing it. On that ground, the whole process was quashed, matter remitted back to the magistrate for a fresh.
For what? What is
For
it?
a fresh inquiry.
Which paragraph?
Sir, last part.
Yes.
It is small, short order.
Telling to the imperial order is on the basis of DGM fee comply with the mandate because under section 201, the issue is required to examine the complaint on the. There is no evidence.
No. Straight away 156.3. Then charge sheet, then cognizance.
There are two different.
Now, one second. Out
Some cases, my lord, there are decisions of this honorable court and appeals court, my lord. Straight away, magistrate can state the complaint itself to the for the registration and register of the case, my lord. And some cases, the magistrate, my lord,
Record the evidence from they are satisfied.
there is no, my lord, there is no necessity.
But how will you get over this? This is in the absence of 201 statements. The cognizance is taken. It has to be-
156.3 should not have been resorted to
That's
directly.
what this order says.
Other cases are there, my lord. Another date, my lord, I will.
Sir, interesting point. What Odisha Forest Act? These kinds of complaint cases cannot be entertained.
Just see the complaint. I understood that point. Show the complaint to me.
Page
What are the allegations?
Page 38. Dekhunandi.
38, huh?
Aye.
Okay, let us understand. ଦିନକୁ
ବିନୀତ ଅନୁରୋଧ ମୁଦେଇ ମାନ୍ୟବର ବିଚାର ବିଭାଗ ଦଣ୍ଡ ବିଧି କ୍ଷମତା ଶୋଣଶ ଛାଡି ଦିଅନ୍ତୁ ଲେଖିଲା ଆମେ ଓଳାସା ଗ୍ରାମର ଅଧିଷ୍ଠାତି ଦେବୀ ନୀଳକଣ୍ଠେଶ୍ୱର ଜୀଉ ମନ୍ଦିର ଆମ ଗ୍ରାମବାସୀଙ୍କ ଦ୍ୱାରା ନିର୍ମାଣ କରାଯାଇ ରକ୍ଷଣାବେକ୍ଷଣ କରାଯାଏ ଠାକୁରଙ୍କ ନୀତିକାନ୍ତି ସବୁ ଗ୍ରାମବାସୀଙ୍କ ସହାୟତାରେ କରାଯାଏ ନୀଳକଣ୍ଠେଶ୍ୱର ଜୀଉ ମନ୍ଦିର ପ୍ରାଙ୍ଗଣ ପ୍ରବେଶ ପଥ ନିକଟରେ 25 ବର୍ଷ ତଳୁ ଗ୍ରାମବାସୀଙ୍କ ଦ୍ୱାରା ବାସଚନ୍ଦନ ଲଗାଯାଇ ତାହାର ରକ୍ଷଣାବେକ୍ଷଣ କରାଯାଇ ଆସୁଥିଲା ଗଛଟି ପ୍ରାୟ 2 ଫୁଟ ଗୋଲେଇ ମୋଟା ହେଉଥିଲା ବର୍ତ୍ତମାନ ଅନୁମାନକ ମୂଲ୍ୟ 60,000 ହେବ ଏହି କି ଦିନକୁ ସମୟ ଶୀର୍ଷ ନିୟମିତ ମୁଦାଲା ଦ୍ୱୟ ଏକ ଟାଟା ଏସି 4 ଚକିଆ ଗାଡି ରେଜିଷ୍ଟ୍ରେସନ ନମ୍ବର ଆସି କଟର ମେସିନ ଲଗାଇ ବାସଚନ୍ଦନ ବୃକ୍ଷକୁ କାଟି ଟାଟା ଏସି ଜମା କରିବା ସମୟ
what is this is the allegation.
But it's not permissible at all. Kindly see Odisha Forest Act. My learned friend would have no answer to that. Chapter 7A. Kindly see.
In fact, my
To
lord,
hold this sandalwood anywhere.
Why don't you pay like such a big give you
Chapter 7A देखो
50
Sir, chapter 7A mu kahi ଦେଇଛି ଆପଣଙ୍କୁ ଦେଖନ୍ତୁ ସେଥିରେ and wherever a sandalwood is there, uni private, it belong to the government, property of the government.
Where is the property of the government? Where is the bar?
Sir, ମୁଁ bar କଥା କହୁଛି ତାପରେ ଦେଖିବେ who will lodge a complaint.
Right.
Complaint will be lodged by the owner of the property. Means the temple here.
Who is this?
The person against whom I have a lot many complaints, cases.
Right. The petitioner has challenged the order dated 21/5/2022, whereby the cognizance order 31/5/2022,
Right.
where the court below has taken cognizance of the offence under section. What is the cognizance order? Where is that?
Here, IPC offense.
379 and
447.
379, 294, 506, 34 IPC.
Page 10.
Thank you.
Page 10. ठीक है page 10. The next one, Mr. Ratho, appearing for the petitioner submits that perusal of the complaint. In the present case, the opposite party number 2 has filed the complaint against the petitioner, inter alia alleging that a sandal tree which was inside the temple was
Cut and removed.
was conspicuously cut and taken by the present petitioner. Present petitioner. On the basis of the said allegation, without recording the evidence, pre-summary evidence, or preliminary evidence under 200 bracket 1 of CRPC, the court below has directed for registration of FIR and under 156 bracket 3 CRPC. Mr. also contends that the police has no jurisdiction to investigate the present case, being a case primarily for violation of the forest, what is it, Orissa Forest Act. He further points out that the sandalwood tree is basically the property of the state, and the complainant should have been the owner of the property. Rather, in the present case, the opposite party, number 1, who has been litigating with the petitioner in many other cases, is intentionally invoke the provision so as to intentionally invoke the provision and malafidely trying to prosecute him. Issue notice, Mr. Ragada accept notice, returnable within 3-4 weeks. Each time Mr. Ratho is relying upon the judgment of order of a coordinate bench passed in CRLM so dated so wherein the coordinate bench had in a similar circumstances, so coordinate bench satisfied the order and remanded the matter back to the court below in the absence of the direction by the court below under 156(3) CRPC for raising of FIR without there being evidence recorded under section 200 bracket 1 CRPC. Issue notice. In the meantime, the proceeding before which court?
In the court of JMFC Bhapur.
ये application लेना page 10
Here case number 140 of 20.
State further orders. Yes.
But can I just request my lord?
Yes.
Police can inquire into subject to a complaint being made by the proper person.
So further submit ऊपर जो लिखे हैं ना police has no jurisdiction. He submits that police can only enter into the investigation once a proper complaint
is lodged by the
owner of
right.
The
Correct.
owner of the tree. In the instant case, the temple is the owner of the
Correct.
The subject tree.
Correct.
Whereas the complaint is filed by the opposite party number 2, who is in loggerhead with the petitioner.
Great point.
Loggerhead with the petitioner by litigating with him in many other.
So
Free copy. Free copy.
Free copy.
Urgent.
Why for state free copy?
I will send the free copy to the police. My lord. That is
State, yes. Okay. Next.
I will tell.
Yes. Carefully करो. ये पुलिस लोग power में को है ना जान करेंगे. Yes. Pass over. Yes.
May I please, Lordship? My lord, the petitioner is a lady, my lord. She is the headmistress of a school. and challenging the entire criminal proceeding initiated against her, my lords.
What is the allegation against?
My lord, allegation is, my lord, during lunch hour,
Hmm.
while some students, small children,
Hmm.
were taking their lunch, the boundary wall of the school was collapsed.
Oh.
And near about 10 to 15 students injured. And while they are shifting to the hospital, my lord, 3 have been died. Only because I am the principal, my lord.
Subsequently, 2 persons expired at the first 2 students.
Although-
Student, my lord,
Five students.
Yes.
and others are injured.
For that reason, my lord, cognizance was taken against me under 6304A.
Right?
And there is no rash and negligence. The wording is rash and negligence. But there is,
Allegations are so serious. Small children.
High person.
my lord. Lordship may call for the record so that it will be clear that whether I am negligent for my work or not, that will be
You
clarified.
are otherwise also liable because you are.
My lord, that is there,
What-
that is there. Because I am the headmistress, I am
Do
responsible
you
for.
have anything to show me from record that you had informed the higher authority that
My lord,
the building is dilapidated?
For
Some
that,
kind of.
for that reason, my lord, your lordship may call for the
They might not
CD.
have a-
I will show, I will show.
Oh, you know police how. to
My
do
lord,
it.
my lord, my lord.
Oh, he might
Whether I have-
161 statement and file.
Whether I have
You
intimated
won't
it,
get it. Do you have any document?
I will collect, my lord.
You collect? it.
Yes.
So show me that you have really informed the senior
Yes,
authority,
yes.
whatever, that this is.
Building committee or some odd, yeah, yes,
Something, some step taken by you. It
Yes.
may be an accident, unfortunate accident,
my lord.
but negligence, what negligence?
Yes.
What extent?
From my side,
You
what,
don't expect that they will collect it.
my,
They
no,
will
no, I'll collect.
take it from you.
My lord.
I've just
It-
simply urgent it.
There may be stay, my lord, but charge was
No,
framed and
stay.
notice was issued to
In
the,
this kind of cases, how can you expect
for,
stay?
for shorter
I am
period,
ready
my
to,
lord.
I am ready to help you. I'm just issue notice. Bring some record so that I can.
My lord, your lordship may keep it to next week, so
you
that I
tell
will
me the date.
collect. Next,
Come with some document.
21st, my lord, your lordship.
21st.
Yes.
Okay. Come with some document.
My lord,
so
my
that
lord.
we can.
Whether I have intimated or not,
Yes, some step you have taken.
My lord.
Despite that,
my lord,
the unfortunate incident.
my lord, my lord,
Then we can very well.
my lord. Public. In the meantime, CD may be called.
We'll see. We'll get it. Yes.
Pardon me, Lord, item number 5, charge sheet certified. Simple in nature.
Past over 2 o'clock.
Probably. ସେ ତାର ଗୋଟେ ପର୍ସନାଲ ଡିଫିକଲ୍ଟି ଅଛି ତା ଭାଉଜ କଣ ଅପରେସନ ହଉଛନ୍ତି ତେଣୁ ତାର ଡିସପେନ୍ସ ଟା ଟିକେ ହେଇଯାଉ ଅଦର ଆକ୍ୟୁଜ ପର୍ସନ
It's a court proceeding. If it is initiated, they have to suffer. What to do? Many people have many problems. You want quashing of FIR, and you have the luxury of coming at your own pace, and thereafter you say that immediately barge into the court and say that you take it.
No.
That doesn't happen.
Sorry.
Let them wait. Let them have the, 307. Wait. Let them wait. Okay.
Item 12, my lord, here 379 is the offense. And last time the Hon'Ble Court has directed the state to examine my contention. That
Yes.
statement except co-accused statement, no other materials is there.
Yes.
ଆସିନ୍ ମାଗିଥିଲି କ୍ୱେଷ୍ଟେଡ୍ 9 ଟୁରେ ଥିଲା ଜଲ୍ଦି ଆସି
କିଛି ନାହିଁ ଆଉ କଣ?
9 2ରେ ଥିଲା ଜଲ୍ଦି ଆସିଗଲା ତ 9 2ରେ ମାଗିଛନ୍ତି
କଣ କରିବା ଆପଣ କେତେ
ଆଉ ଗୋଟେ ସର୍ଟ ଟାଇମ୍
କୁହନ୍ତୁ ଆପଣ କୁହନ୍ତୁ ଟାଇମ୍
ନେକ୍ସଟ
ନାଇଁ ଆପଣ ଯଦି ଆଣିପାରିବେ ନେକ୍ସଟ
16
16 no why 16 let it be 19 or 20
That's-
19 or 20 20th okay. Yes 13
May I, lordship?
yes
Here, my lord. A petitioner challenging the order of the lower court under annexure 7 on
what
the
happened then?
on the ground of res judicata. Fact of the case is, this is the NI Act case, and the petitioner in the accused.
Criminal case what res judicata?
Yes, the opposite party has filed several times under section 6, order 6, rule 17 petition for amendment of the plaint. Your lordship kind of a glance.
Plain?
Yes. Your
This
lordship,
criminal case plain. What is plain?
this is 138 NI Act.
So what is the order 7 here?
Oh, yes, Your Lordship, kind of a glance. He has filed order 6 rule 17 of CPC to amend the plan, and thereafter 3 times he has filed.
Show me.
The court was rejected earlier, but now allowed,
Where is that?
which is challenging. Your Lordship, kind of a glance, Annexure 7.
You are the accused.
Yes.
Hmm.
Annexure 7, page 45.
Yes.
In earlier occasion,
Now, where is the application? Where you order 7?
yes,
7 level application.
yes. Categorically I have observed.
Where is that? Merely using the word amendment doesn't mean that order 7 rule 11.
Yes. Lordship, kind of glass, page 21. This is the first application under order 6 rule 17 filed by the
Where is 20?
Annexure 4, page 21. Lordship, got it?
Yes.
Yes. This is the petition filed by the opposite party and application under order 6 rule 17 of CPC. Lordship, kind of glance, page 22, proposed amendment.
What is the amendment? Amendment short. President describe which is scheduled below. The proposed amendment is a simple form of what is the amendment?
Yes. In para 7, para 7, subpara D, line 2 of the complaint petition, after the word Indian Bank and before the word branch, the word Kendrapada be deleted. Fact of the case is,
In place of Potamundai?
Yes.
These are, see, merely using loosely one word, order 7 rule 11 will not defeat.
Yes.
Only the typographical error is correct.
Yes.
Okay, next.
Allowed. Your Lordship, kind of glance, thereafter,
That's right. Okay, next amendment.
next amendment.
Yes.
And page 29, Annexure 5 series.
Yes, I am on that. What is the schedule?
Schedule in para 4 of the complaint petition, that is name, age and address
Of the witnesses.
of the
number 3.
witnesses, number 2, the word branch manager of Indian Bank and before the word
Same amendment.
same amendment.
Same amendment. What is wrong in it?
Wrong this
Merely
because
because order 7 rule 11 at the top it is written.
no, because
You are an accused, you have to pay the check amount.
no, it is false case. It is a false
That
case.
will be tried.
And your Lordship,
What is
kind
the check amount?
4,50,000.
So show me your reply to the statutory notice.
Yes. Notice I have not under your Lordship, kind of a glance.
Legal notice is there, but where is
Yes,
the reply?
page 20, Annexure 3.
Yes. This is the legal notice given by the
Complainant to me, which has not received me. And your Lordship, kind of glance.
where is the complaint copy? Where have you said that you have?
Yes, Annexure 1.
Annexure.
Complaint petition, Annexure 1, page 12.
Yes.
And page and initial statement.
Show me that where the legal notice was complained.
Yes.
So para E,
That is,
come to
yes,
para E,
para E,
complainant
E.
issued legal notice
Page,
brought to the law.
page 40,
Intimating about this one, check about 7 days.
7 days. Your Lordship, kind of glance. This is statutory provision 15 days. But he has
Accused received the said notice and intentionally so and so.
this is his contention.
What is the check amount?
4,50,000. Your Lordship, kind of glance, page 14 C, paragraph C, D and E. Paragraph C, last 3 lines. Check number so and so of Bank of India, Kendra branch bearing.
Actually, the complaint is drafted by a very young lawyer, maybe making a lot of mistakes, typographical mistakes.
So many mistakes are there. Your Lordship,
And you are taking advantage of that.
no, not advantage. So many mistakes are there. And 3 times amended.
In the check, your signature appears. Why have you not replied to the statutory notice then?
Reply, I have not received.
He makes an error.
He has written. In fact, I have not received. And when I received the notice from the court, I appeared and
Where
objected.
You tell me one thing.
Yes.
In the check, your signature appears or not?
Signature is there because that is blank.
Then 139 presumption. You have to face the case.
But
I'll simply issue notice just to explore the possibility that the 4,50,000 check, if you pay installment and all, we'll fix it, tap and finish.
No, I have not issued the check.
You said your signature is there,
Signature is there, but I have not issued.
that then 139 presumption read, presumption operates.
Yes, yes.
The statutory notice is given,
Yes,
whether
yes,
it is
yes.
received or not is a tribal thing.
He has amended.
He in the complaint, he says that I have given it and he received it and you dispute it. The dispute can be resolved in the trial only. I
Yes,
can't
yes, yes.
inquire into it.
Yes, trial is
So
going
therefore,
on.
Inevitable.
Trial.
And what is the correction? Correction is
My lord,
only in place of Kendra.
My lord, one thing.
Kendra Pottamandai.
one thing. Trial is going on. After conclusion of the evidence of complainant, he has filed further amendment, which has been rejected by the court earlier.
Amendment is only typographical error. Man. In place of Kendra Pottamandai.
Your lordship, can I have a glance one document?
What is this?
For page 49.
No. 49, I'll just see. What is that?
That is return memo. Mention Indian Bank Kendrapada branch. But now he says Indian Bank Pottamandi branch.
You will be.
This is exhibited document. Exhibit 3. He has been.
In the side it is written Pottamandai.
My lord?
Side in the handwriting it is written.
Handwriting?
What is this? Pottamandai.
No, my lord. Return memo, page 49.
Yes.
Page 49, annexure 8.
What is written in the handwriting?
Return bank return memo. Your lordship, can I have a glance? Indian Bank Kendrapada. He has deposited the check before the Indian Bank Kendrapada, not Pottamandi. But now says Pottamandi and amended several times. That is my contention.
That's good for you.
Yes.
You will be executed.
Yeah, that is my contention.
You will be executed.
But court below.
If an amendment wrongly or rightly is doing, which is genuine to your benefit,
Yes,
enjoy it.
Yes.
Enjoy it.
But repeatedly filed amendment petition, court.
For you, you will get executed.
Court rejected, court allowed. I am suffering.
You are not suffering. He is suffering. He is.
No, my
You
lord.
have issued a check and his money is stuck.
Your lordship, he deposited check before the Indian Bank Kendrapada branch. Now he prayed that the Indian Bank Pottamandi branch.
For you, then you will be executed.
No,
Why don't you argue that?
No,
There.
that's true.
You argue that instead of getting it corrected once again. Apparently a defense which is genuine to your benefit. You want to get it corrected.
Several times I have objected before the court below.
Let it be there on record so that you will
Yes,
get it. Don't get it corrected. It's better for that you that don't correct, so that you will get the benefit. If it is corrected, then you are gone.
Yes, that is exhibited document by him.
Let it be like that.
Exhibit 3.
Like that. I'll just issue notice if you want.
As
to
your
explore,
lordship.
but no.
As your lordship.
I'll just issue notice.
Yes.
Just issue notice. That's it. Just issue notice because it's 138 case. If he comes out, then some settlement can be worked out.
Date may be fixed.
He will fix it. Short date there. 5th March. Yes. Next.
Item 14, may I please, my lords. My lords, here I have come before your
Item
lordship.
14. Today morning, I have received the bulky brief. He has challenged the cognizance order and proceeding.
Let him read.
My lords, I have no objection if your lordship adjourns, but I had served the copy on 8.
ମୁଁ ମନା କରୁନି
I totally understand.
next week.
When do you want? First week. That is on 1st of March. 1st March.
I pray for a shorter date, my lords. Any last week of February, my lords.
Then the next week, yes.
28,
Next week,
29,
yes, my lord.
28, 29. 80 matters, it's not possible.
I
Take
understand.
Only 2 minutes also,
My lords.
Mm.
I'm deeply obliged.
Yes. 50. Yes.
May I please, your lordship? I'm challenging the order of cognizance, your lordship. That is available to your lordship is Annexure 3 on the ground of compromise. It's a matrimonial dispute between husband and wife.
Who are they?
Well,
Are they-
so
are they
one
here?
is husband, 2 is brother-in-law, and 3 is sister-in-law.
You have physically attacked her.
My lord,
You have physically attacked.
no, my lord, the charge sheet was some cognizance on the
307.
307 was deleted from the charge sheet and cognizance was taken 490 days.
Okay. Are they here?
No, my lord,
Will you
no,
bring them?
notice, my lordship.
Okay, the petitioner is challenging the cognizance order dated 9/5/2022 passed by the learned STJM bracket S Cuttack in GR case number 1268 of 2021. 2021 arising out of CDA-2 PS case number 82 of 2021. Under section 21 full stop. This is a matrimonial dispute. Charge sheet has been matrimonial dispute. The counsel for the petitioner submits that the parties have settled their dispute.
Compromise petition is annexure 4, your lordship.
Settle their dispute, and a compromise petition is placed on record as an Excel 4. Issue notice to the opposite party number 2.
That is what they have filed, my lord, annexure 4, my lord. But in fact, here one they are filed to join.
Right. Issue notice to the opposite party number 2. Opposite party number 2 returnable within 1 week. Within 1 week. In the meantime, the parties may file a joint affidavit inter alia, bringing the terms of settlement on the record by next date of hearing, and the parties may also present in the court either through personally or through video conferencing mode. In the meantime, the proceeding before
So that will be given a CDA from CDA, my lord. All parties will come.
Next week.
Let them come, whatever. Proceeding before so and so, if is state. Yes.
Obliged.
Next.
16.
Kindly permitted to withdraw, my lord.
Very good. Take. Withdraw. Move on. 17.
17.
Item 17, 18 and 19, my lord, on behalf of Mr. Kaviraj Pradhan, let the matter be adjourned to some other day
Adjourn.
so
19.
that the opposite party short date may be kindly fixed. Either day after tomorrow.
No, day after tomorrow may not be possible.
The
We adjust it.
The opposite parties may appear so that,
Certainly.
yes, in this matter, the opposite parties may appear. This is a village dispute and the compromise is already
1 CC
conducted.
cases.
1 CC case, my lord.
Let it be, give it next week. Let them call all the parties so that we.
Yes, they will appear, my
When
lord.
do you want?
Adjournment, my lord.
When do
Short
you want?
adjournment. Any day, your lordship, this week, any day.
22nd. Maybe तीनटा metro 15 April. Will only settlement. All of them will come.
Yes.
Actually,
Yes.
Don't waste because
No, my lord. Your lordship may.
It's all 3 cases, bits in one, but complaint different.
Bring them and finish it up.
Yes,
Don't
my
take
lord.
good time.
Not today, not
Date
today.
don't go to date.
Any day, 16?
16.
All
No
right.
last time on that day.
Yes, ma'am. Obliged.
19. All the 3 meters. 17, 18, 19, 20.
20.
May I please, Lordship? The petition challenge the Mahila order of cognizance dated 21/10/2021 passed by the learned special judge.
It's all right to what is the case?
Case Mahila, spurious dogs has been seized from the petitioner Mahila, for which the 2 cases were initiated against this petitioner Mahila. One, my lord, by annexure 1 and annexure 2, my lord. 2 cases, same cell occurrence, 2 cases registered, my lord. And another ground, my lord, the police has no power to investigate and charge sheet in case of dogs.
Where is the charge sheet?
Charge sheet is, my lord, annexure 3, my lord. Annexure
Three is the
3.
cognizance order.
Yes, my lord.
Where is
2 is FIR, my lord.
no FIR? I can understand. Where is the charge sheet?
Charge sheet, my lord. I'm not submitted, I'm not filed.
Counsel for the petitioner,
Order of cognizance.
seeks them to file a copy of charge sheet on record, adjourned to first week of March. Yes. Pass over.
22.
May I please, Your Lords?
Yes.
The order taking cognizance is under challenge before Lordships. And the entire, I have also sought for the washing of the entire proceedings so far as the present petitioners are concerned.
What is
Offense under section 420, 294, 506 and 34 IPC. It arises out of a complaint case, my lords. Initially, the complaint case was referred under section 156(3). PS case was registered. That culminated in a final report, and the investigating officers submitted that the entire case is a false case. Thereafter, again, she was noticed. The complainant was noticed. She appeared and filed a protest petition that was treated as a complaint, and thereafter 200 and 202 inquiry.
Right.
The entire case of the complainant revolves around this execution of a sale deed, and her grievance is that I have not received a part of the consideration amount, and my husband was supposed to get a job in NALCO for this sale matters. I'll take
What
you.
are you in the NALCO?
I am, my lord, these two petitioners, they are officers of NALCO as GM and AGM.
You have promised that
No, my lord, that is not the
I'll
case.
purchase and give you job.
The property has been, the land in question has been purchased by NALCO. This is not, the purchase is not in my personal capacity. The land has been purchased by NALCO, and only this petitioner number 1, petitioner number 2 is also not even in the entire picture. And so far as the accepting the allegations of the complainant, her case, entire grievance is against the other 2 co-sharers who have received the amount and they have not paid
Give
the
this amount from NALCO.
NALCO. The demand draft has been by way of a demand draft. If you lot see, I have annexed the copy of the sale deed, the recitals of the sale deed.
Beneficiary is the NALCO.
Yes, my lord. NALCO ko hi deliver
Where is 200 inquiry?
Yes, my lord. I will take your lordships to page 76. 202 inquiry, page 76 and 77.
So one page.
Yes, my lord. 76 and 77.
Come on.
Shall I place, my lord?
Read it.
This is the 202 inquiry of the complainant.
Read it.
I have filed case against the accused persons regarding the sale of the suit land.
76.
Page 76.
Handwritten.
This is handwritten.
Yes,
202
I have filed
inquiry.
a case against the accused persons regarding the
Sale of the suit land. The land bearing khata number 916. However, I cannot say the plot numbers. During the lifetime of my father, around 4 to 5 years back, the accused Dasaratha Samal used to take my father to Hon'Ble regarding sale of the land in dispute to NALCO. I don't know anything about the affidavit dated 15/11/2016. My father being an uneducated person, the accused persons must have taken his signature forcefully. I did not read the contents of the sale deed. The NALCO employees said we would receive a lot of money in return. Hence, I put my signature without knowing the contents. Thereafter, I know how to read and write in Odia. Nothing, my lord,
Yes.
even if
Since a complaint case was filed, my lord, in shape of protest, my lord, notice has to go, my lord.
No, notice will go, but what is this?
This type of case, my lord,
He is not.
or that is the police submitted final.
He is not the
My lord.
purchaser. It is the NALCO.
My lord.
And
Or
they are
that
the
is the
employees.
final report submitted, my lord.
I can understand if they have taken the property. I can understand.
Exactly, lord.
What is this?
Notice will go.
Well, issue notice to the opposite
Opposite
party in number 2.
yes, madam.
Opposite party number 2, retainable within 2 weeks or 3 weeks, whatever it you will. Land council. Mr. Behra, Land Council for the petitioner. Points out that the 156(3) application was moved by the petitioner. Where is that? By the opposite party number 2 against the petitioner. Inter alia alleging that they have defrauded him by not paying the sale consideration of the property, they are not paying the sale consideration of the property sold to NALCO, and they have not kept the promise of giving job to his kids,
To her husband.
to her husband. Full stop. The 156(3) complaint was converted to an FIR, and a final report was filed. Thereafter, by way of a protest petition, the opposite party number 2 laid pre-submitting evidence, laid preliminary evidence under section 202, 202. In the perusal of the statement under 202 indicates that there is no allegation per se against the petitioner here. The petitioners are not the beneficiary of the sale of the land, rather it is the purchase by NELCO, where the petitioners are the employees.
Yes, madam.
Employees. Issue notice to the opposite party member 2, written with so and so, and in the meantime, further proceedings take. Yes.
Obliged.
Yes.
May I please, your lordship? Lordship, I have challenging the order of JMFP Esoma under section 457, under section 457, and under section 397 revision of passed by the learned ADJ Kujam. And the fact of the case is that SI of Abhechandpur police station lodged an FIR that the manufacturer is running illegal manufacturing tobacco manufacturing unit. That is absolutely not correct. The manufacturer is running chewing tobacco manufacturing unit, and the manufacturer has written all the document. Your lordship may kindly see page number 14.
Release of goods you want?
Yes.
Annexure 1.
Yes.
Perishable goods or what?
No, there is a tobacco product and machinery items.
Will issue notice him?
Investigation progress, madam.
Let us issue notice. Issue notice. Let us. Yes. Next.
Obliged.
24 may I please?
Issue notice. They will mark. Yes.
24 may I please?
Yes.
Belgium case where she there's an prisoner was bail was
You are not on bail.
I mean bail in 25/6/18.
20 first month.
No, my lord, what happened in this case, my lord? One petition number, my lord, 2 on court bail, my lord. So, but 2, 3 are concerned, my lord, they have filed antecedent interpretation. During that interpretation, charge sheet submitted. Whether, my lord,
Okay, it's all right. The petition number 1.
1 on court bail.
1 was bail. On
Madam.
bail. The petition number 1 was on bail. White order did it? No order.
Page annexure 1 page 8. Page 8, my lordship. Order BLPL number 1847.
2, 3. So, but 2, 3 is concerned, they have filed antecedent bail option. They are.
Let the counsel for the petitioner submit that insofar as petition 1 is concerned, he was in bail. However, insofar as petition number 2 and 3 are concerned, they were on interim protection by the court below. The interim protection by the
Honorable lordship.
This court.
Honorable court.
This court.
ABLPL number. Yes, ma'am.
During the while they were on interim protection, the charge sheet has been filed, and the petitioner had defaulted in appearing in the court below, leading to issuance of NVW on 24/1/2023. Okay. 1st March on section 1st March 500. 500 rupees.
Yes, cost 500 rupees.
High Court of Orissa.
Yes. Obliged.
Why are you so confused? What, you have any problem?
Not my lordship. Man, I have.
Why don't you? It's not a big matter. Why don't you confidently argue?
Not a pass over, my lordship.
Why pass over? I've done it for you, but try to be confident.
One difficulty is that, my lord. in that anticipatable application, my lord, that has been disposed of with the direction to surrender before the court below.
Anyway, they have not done, they will doing,
Well,
they will be doing.
When NVW issued my lordship, he has fixed the date, my lordship, but due to he has
Anyway, you now, I am giving 1st March, on or before 1st March, go and surrender and avail whatever remedy you have on law, and I am setting aside.
setting aside, my lordship. Obliged.
Just, I just, I.
I have challenged the order of cognizance, my lord.
Yes.
Which was arisen out of a protest petition. Offences are 376D A and
363, 363.
apart from that, my lord, the
376
major offense
DA.
376D and POCSO Act is also there.
The, at the instance of opposite party number 2, the FIR number so under section so came to be registered against a petitioner. Next, so secure for petition respond. The counsel for the parties jointly submits that they have their clients have settled their dispute.
We have filed a joint affidavit
They
to
have
that,
filed a joint compromise affidavit,
which was shown,
dated
before Oath Commission.
dated 24/1/2024. Inter alia stating that they have settled their dispute and the petitioner, the opposite party number 1 is not interested to carry on with this matter against the petitioner.
Opposite part number 2, my lord.
Mr. Ragada appears for the state, submits that the offences are minor in nature and most of them are compounded. Since the parties have settled their dispute, there is no legal impediment in watching the FIR. Taking into consideration the aforementioned fact and submission at the bar, the so and so is passed.
My lord, opposite part number 2, my lord.
Yes, I have taken. You are appearing. Yes.
Obliged, my lord.
May I please your lordship? The petitioner challenge the order of cognizance taken by Learned.
You are also appearing.
I am appearing for OP number 2, my lord.
Notice was issued.
No, madam.
No.
Present.
In fact, CS sir, arising out a complaint petition, your lordship, the magistrate has taken cognizance of such offence, which one of the offence is 497, which Honorable Apex Court has been pleased to struck down. Despite that,
That is decriminalized.
497 has been decriminalized, your
By
lordship.
the Honorable Apex.
Honorable Apex Court in case of Joseph Sen, your lordship.
Yes.
And if
So, but
as far as
I'm appearing for the opposite party number 1, madam.
and
2, madam.
as far as offense under 6,
This is a very peculiar case. Peculiar, why I'm saying,
That provision has to go.
Yes, one provision go.
why I'm saying it's a peculiar case. The unfortunate complainant, who is opposite party number 2, he had taken his wife for operation, IELTS operation, for whom my learned friend is appearing.
Okay.
My lord, operation was conducted by the present petitioner, which is a doctor, surgeon. So after operation, for post-operation care, my wife was advised to go and to be
Treated by
yes
post-operational care.
in course this of post-operational care. Now, my wife was kept by the doctor.
Long treatment was required. What to do?
One of the peculiar case, Melody, if doctor will be the one. Here that has happened. Whatever it may. My father-in-law.
You want to prosecute?
That's prosecute for 498. 497, my lord, 2019, volume 3, SEC is staring at me.
So he's challenging to that extent only.
No, your lordship, entire order of cognizance I am challenging.
Whether accepting the entire case of the complainant, 498 and 506 is made out or not. Yes, I'm quite concerned about 497, though it has been subsequently dealt by the apex court after the judgment of Honorable Justice.
498A.
498. 498.
498.
498. For my lord.
Only 98. Not 8.
Your lordship, I invite my lord's kind attention to the provision as well as ingredients of 498, your lordship.
No.
No, yes.
Because my father-in-law has approached, he was misbehaved by the doctor as well as by his daughter.
Have you initiated any proceeding against your wife?
Yes.
Separation or anything?
Yes.
Divorce petition you filed?
Yes. And that doctor is also earlier married. Against him, divorce case is there, maintenance case is there, 307, 498 a case is there. After all, if a lawyer valid, because we are there is a privileged communication. 126 Evidence Act says communication between advocate and the client, doctor and patient, husband and wife.
That's right.
But if a doctor violating Medical Council Act will treat the patient, it will treat the patient in this way.
But that is not invoked. That provision is not invoked. Only
497, 498 and 506. Well, let me see whether 498 and 506 is made out
or not. That's all.
Yes.
Your lordship,
Yes.
498,
Yes.
with all respect to my senior, 498 says, your lordship, enticing or taking away or detaining with criminal intent a married woman, whoever takes or entices away any woman who is and whom he knows or has reason to believe to be the wife of any other man, from that man or from any person having the care of her on behalf of that man, with intent that she may have illicit intercourse with any person, or conceals or detains with that intent any such woman, shall be punished with imprisonment of either description for a term which may extend to 2 years.
You didn't know that she is married?
Your lordship, she is not staying with me, she is staying separately. I am no way involved. There is not a single line to the deposition before magistrate under 202 statement, as well as in the complaint petition, your lordship. Now, I invite my lord's kind attention to the complaint petition itself, your lordship.
Yes. What are the links?
Starting from page 11, your lordship.
The two number on.
Love marriage. Let me see from paragraph 7. Enter file.
Yeah, all allegations are there.
Your lordship? No,
All
your lordship.
allegations are there.
Lordship.
Whatever the facts he is saying, everything is there.
Everything is there.
He went for the treatment and post-treatment.
Your lordship, treatment, post-treatment is,
Thereafter,
that is there.
You develop the
No.
relationship.
There is nothing like that, your lordship. It is the person who can say the best
Whether
person
it is
who
correct or not, I am not examining.
Lordship.
Whether the allegations are there or not, that I have to examine. Allegations are there.
My lord, relying upon.
As simple as that.
My lord,
I can't go to verify whether this is correct or not. The fact that there are allegations.
Lordship, lordship.
Yes.
My lord,
Read page 12 and 13.
Lordship.
Minute details.
Lordship.
Of allegation. What else you need for cognizance?
No, your lordship, it cannot be because it does not fulfill the ingredients
Unfortunately, that is the law.
498, your lordship.
Unfortunately, that you have read the provision.
Yes,
read the
lordship.
allegation.
Lordship,
It is
I have
my-
gone through lordship. That is why I am before your lordship.
Yes, tell me. No problem.
Lordship.
But allegations are there.
The complainant and his entire family, para for, as observed by my lord at page 12, your lordship, that the complainant and his entire family.
What is the stage of trial?
Lordship.
Cognizance has been taken back.
Cognizance has been taken.
You argue at the appropriate time.
No.
If at all you want.
Your lordship, it's
According to me, prima facie case is made out. I read the provision. I read the allegation. I need not further.
I invite my lord's kind attention to the deposition, your lordship.
I can't.
Deposition, your lordship, basing on which.
Up to the allegation and see the evidence and find out is correct or not. Cognizance.
Your lordship,
Only
in a case, lordship, in a complaint case, cognizance is to be taken after taking the initial statement, your lordship. I invite my lord's attention to the initial statement, your lordship, starting from page 19.
Page 18 you read. That's the reason it is said that the affidavit has to be supported. There is an affidavit. It is like examination in chief. And in the affidavit it says that the facts stated in above are true to the best of my knowledge.
That is part and parcel of the complaint petition, your lordship.
That is enough. The allegations are there in the complaint. He gives an affidavit to say that yes, this is true to the best of my knowledge.
Your
and
lordship,
thereafter,
there is-
a case is made out and cognizance is taken. And if you have a good case, you may be correct. I am not saying that you are not correct. You may be correct, but which stage it has to be examined? It is not at this stage.
Your lordship, it is Honorable Apex Court taking into consideration the case of Bhajanlal and other. He has kept your lordship in mind. And in a recent case, your lordship of
Which
2000,
exception it comes?
it comes to the very first exception, your lordship, not a single ingredient
Read that
come out, your lordship.
Read that exception.
Lordship.
First one.
Yes, your lordship. Where the allegation made in the first information report or complaint, even if they are taken at their face value and accepted in their entirety.
Okay, face value, take it and the court is
Face
satisfied.
value, your lordship, the language expressed in 498, it does not come, your lordship, not a single word to that. She is saying she had a illicit relationship, while the wife of the OP2 has today entered by way of an intervention application. She served a copy just now to me as well as to State Council.
He is also an accused.
Lordship?
He is also an accused or not?
No, she cannot be an accused, your lordship.
He is not. Okay.
Court has not taken cognizance of the view of that. When she says she is not staying, she is
Their wife
staying
and
something.
husband. Their wife and husband. You
Not
are
at all,
the-
your lordship. Not
you
at
are
all,
the-
your lordship. Not at all, your lordship. How can it be?
You are the intruder in their life. That's the allegation. What you do.
Yes.
May not be correct also. You whatever you say may be correct, but the allegation is
Lordship, kindly have a glass to the deposition, your lordship. Thereafter, whatever my lordship come to a conclusion,
19, page 19.
Lordship 19, your lordship.
Read it.
I am the complainant of this case.
Next one. Accused.
The accused, one is my wife and accused number 2 is my acquaintance.
I filed
I have filed
the complaint.
the complaint,
They are
both of them, they are cohabiting with
prohibiting with each other.
lordship.
What else you need?
Sir, a simple statement, how it can be, your lordship, it says,
So I will dismiss you with writing or you will take the liberty to go and argue. Don't waste your case. Unless learned counsel for the petitioner seeks to withdraw the petition to raise all the all the points he has raised in this petition at the appropriate stage of the at the appropriate stage before the court below. The petition is disposed of with the liberty as well. They are cohabiting. Everything is written.
Your Lordship, somebody say a gesture that would amount or that will
See,
suffice your Lordship.
Today, the only in the cognizance stage, I have to see that much only. Whether allegations are there or not. Allegations are correct or not, that will be analyzed at different stage.
Lordship,
Oh, anyway,
says with criminal intent, where it is your Lordship.
now, if you want, I will write a full judgment. If you want, I think.
Which due apology, your
No,
Lordship.
I'm just asking, do you want a full-fledged order?
Lordship,
Huh?
Lordship.
A judgment trigger, you submit.
Lordship, I am simply I may be permitted to place 2 lines, your Lordship.
Why are you spoiling unnecessary? You have opportunity at charge stage, you can argue all these points.
Lordship, in
Keep
complaint case, that will be again at the stage of accused statement, your Lordship.
Okay, that's
The
fine.
process.
See, you have a better, at this stage, if I will give some observation, it will unnecessary.
Lordship,
I have to, see, you are insisting me to give you observation, I have to give.
Lordship, only 1 line I submit, thereafter whatever my Lord.
Do, yes. For your satisfaction, you do it. There is
No, sorry, your Lordship, just to satisfy my Lord, your Lordship, 498, enticing or taking away or detaining with criminal intent a married woman. This is what the act says, your Lordship. There is no allegation that I have kept her with criminal intent, your Lordship. Their criminal intent has to be there, your Lordship. That is the basic foundation, your Lordship. I extend it, your Lordship.
I understand it. I think this much I understood it, but that has to be proved in the trial. In cognizant stage, I will see whether intention was there or not. Allegations are there, as simple as that.
Your Lordship, I may be permitted to go through by using a device. There is a judgment, your Lordship, Premnath Laraya versus Step 1972. To uphold a conviction under Section 498, it must be proven that woman has enticed or brought away from her.
What is the sentence to uphold the?
To uphold a conviction.
Then unless you undergo the rigors of the trial, how
Your Lordship, the law decided.
You are cognizant stage, don't forget that. Before arguing, don't forget that we are cognizant stage. What is the requirement for cognizant? Allegations are there or not? Prima facie case made or not? Whatever you are saying, absolutely correct. Even if, whether it is a cognizant state, can the court go into all these things? So that is the reason I am giving you a liberty. If you want a order, then I will definitely, it is your job you are doing, I will have to do my job. Then it may, create some problem for you at the, because your High Court's observation may hurt you somewhere. So that is the reason I am giving you the liberty to raise.
Lordship.
Sorry, I can't give you a relief, but what to do?
No, your Lordship.
You have done your job, I have done my job. Okay.
But the law is well settled, but I will take care at the stage of.
Yes.
497 at least जाओ Lordship. 497 तो cognizance तुम सही part टा पढ़ो.
Yes, note of Joseph Sankar Mishra Union of India.
Where is that? The petitioner has challenged the order dated 22nd July 2023, passed by which court?
Lordship, JMFC 2.
Rare you should write all these things.
JMFC 2.
We have written. Sorry, JMFC 2 in ICC case number 2875 of 2023, which is the order. That is the order is yes, whereby the court below has taken cognizance of the offence under section 497 or 498 or 506 IPC against the accused number 2. Accused number against the petitioner. The petitioner seeks indulgence of this court at this stage. The learned counsel for the petitioner submits that insofar as the offence under section 497 IPC is concerned. What is that judgment?
Lordship, Joseph sign.
Joseph Shire versus Union of India, reported in 2019, volume 3 SCC, case 39.
The Honorable Supreme Court has had declared declared the offense to be
Decriminalized.
struck down.
Struck down.
The offense is struck down from the statute. So therefore,
As it has offended
therefore the
1459.
taking cognizance insofar as the state offense is concerned is not tenable under law. Therefore,
Describing the same as a civil wrong.
yes. Therefore, the cognizance order, impugned cognizance order, which is the offense under 497 IPC is set aside. However, insofar as the other offences are concerned, the petitioner seeks liberty, have this court to raise raise all the points before the court below at the appropriate stage of the trial, and with this liberty, the petition is disposed. Yes.
Obliged.
Yes. 28. Yes.
Application under section
205.
Yes.
Why will you not go?
Has been rejected.
Why? Why? What is the problem?
Problem is a cancer patient.
Oh,
Petition is a cancer
where
patient.
is that? What is the offense, by the way?
But all the offences tribal by magistrate,
Oh.
419,
Where
420.
is the document? Cancer patient document.
My lord, I have given all the medical
Medical
report
report.
annexed 3 series starting from page 43.
You are on bail? No, man.
What?
Are you on bail? No. No.
Bail, no. So bail held for 205. No?
Anticipated
This is
bail.
an application 205.
I know, but you first appear, get the bail, and thereafter.
No, tapar the 317.
317 you move.
Tapar 317.
317 you move, appear through VC. I'll write everything.
और bail दे देले भी छोड़ेगा
Bail
कुछ
कितने? Anticipated.
otherwise to my lord, you kindly see if cancer patient cannot appear on each date of posting, my lord knows that, and I have
But
given the entire
first-
paper.
First day you have appeared, na?
My lord, yes, I have appeared through a lawyer. I have appeared through a lawyer. Otherwise, in 205 টা দিল্লি কেমনি?
You have to give the bond, get the bail and all.
না রিলিজ হয়ে গেলে তো 205 not met. No, my lord knows that already Supreme Court has said. My lord,
317 is there, you move 317, appear through VC.
but I will
you
go. My lord knows if I.
This is the indirect way of getting bail.
Exactly. But no, bail hele tak each date they will appear. But here this is a personal offense.
What is the problem in appearing once and getting bail?
Bail again দেবেন না ভিতর করে দেবে
Thank you.
না
Offense code কোন offense হচ্ছে কোন?
তো এই ট্রাইব্যুনাল ম্যাজিস্ট্রেট offense দেবে না এবার 205
ভিতরে করে দেবে।
my lord kindly see 205 দଉନାହାନ୍ତି କହୁଛନ୍ତି 471 is a punishment is life, so I will not grant.
ଆପଣ ଯାଉନାହାନ୍ତି ନା problem. ଆପଣ ଯାଆନ୍ତୁ କେମିତି ହବନି ଦେଖିବା। ଆପଣ ଯାଆନ୍ତୁ ଏଇ offense ଯାଏ 420 468 71 ରେ bail ମିଳିବନି।
ଏ ଦଉଛି ଜଜମେଣ୍ଟ ଟା ଦେଇ ଦଉଛି ଯାହା ଯୋଉ ଗ୍ରାଉଣ୍ଡ ରେ ସେମାନେ ରିଜେକ୍ଟ କରିଛନ୍ତି 471 ରେ ଆଜ୍ଞା ରିଜେକ୍ଟ କରିଛନ୍ତି ଯେହେତୁ ପନିଶମେଣ୍ଟ ଅଛି ଲାଇଫ. I am giving the judgment, my lord, kindly see. This honorable court judgment, kindly see.
205, why should I get into?
It's 205 re 205 re judgment.
I will give all observations, and you go as and when required, you appear and move application at 317. I will give that observation, go and do it.
But so far as release of accused is concerned, that is the sole difficulty.
I can't.
That is sole difficult.
What do you want to show?
That first decision is the illness ground, my lord, kindly see 205.
Yes, yes.
Yes, Nushan Charan Jena, my lord, kindly see.
Which para?
My lord, got it. And lord, so far as 471 is concerned, kindly turn to page 16. Page 16, another judgment.
16.
Yes, another judgment. Unfortunately, I was the counsel.
Yes, yes. Tell me 16. What? Have you given this set to them? No.
I'm just
Give
sorry.
them, then how will they?
Yes, yes, I'm giving a copy.
Give it. Yes.
I'm giving a set
16 here, tell me.
ମୁଁ କଭର କରିକି ଦିଟା ଜାଗା ଦେଇଛି. one is my lord illness, second is 471 ଯୋଉ ଗ୍ରାଉଣ୍ଡ ରେ ମୁଁ ରିଜେକ୍ଟ କରିଛନ୍ତି. But tribal by magistrate offense, how my 205 the land court will have rejected? I failed to understand. A cancer patient, I submitted entire document. Not that, but this is a higher offense.
You tell me which paragraph.
My lord,
You have told me so many judgment. Which paragraph? I will keep on reading this thing.
verse page 16, my lord 471 is concerned.
Yes.
1/6.
Which paragraph?
1/6 offense is 471. Alleged offense are 471. Learn trial court has said, since offense under section 471 is there, I am not inclined to grant 205. So many judgments so far as 471 concerned, my lord will find.
PG public functionary.
Yes. The active Bhubaneswar are there. Next is also 471. Next judgment starts from page 18. Starts from page 18, my lord. That is also my lord, allegation under section 471 is there.
Yes, Mr.
Well, all the cases, my lord, cited by some of the cases, my lord, 16 and
No, see the
all the
medical.
cases, my lord, arise out of complaint cases, my lord. Their case, my
But
but here, my lord,
Hmm.
he has filed anticipatory application, my lord.
That is
Mr. Aloko directed him to appear before, directed surrender before the court below.
that
He has not
is
complied that order, my lord.
I
He can file 205, my lord.
That's the
I surrendered.
surrendered
No surrender.
Surrender of the recovery.
Yes. I surrendered through a lawyer.
through a lawyer.
Yes.
That's what he said.
Yes, sir. That is and insist
But
a
this-
cancer
Where is
patient.
the 438 order?
Yes, you can't insist
But,
a cancer patient to
In
go behind
BLFL
the
number,
bar.
my lord, in BLFL number 1386 of 2000.
Where is that order?
ଦେଇନାହାନ୍ତି
Please
ସେ,
take on.
ଦେଇନାହାନ୍ତି।
ପଢନ୍ତୁ ଥିଲା ପଢନ୍ତୁ
ଆଉ ଦେଇନାହାନ୍ତି, ମୁଁ ଖାଲି
ପଢନ୍ତୁ
ଟିପି ଦେଇଛି।
ପଢନ୍ତୁ
ଅର୍ଡରଟା ପଢିନି, ବାହାର କରିନି, ଖାଲି ଟିପି ଦେଇଛି ଅର୍ଡରଟା, ଏଇ ରିକ୍ୱେଷ୍ଟ କରିଥିଲେ ବୋଲି।
let it be tomorrow then.
My lord,
Tomorrow you examine this
my lord.
and examine the medical record. What
Yes,
best
yes.
could
That
be done.
is that is more different. If it is
Sort of
pure,
forget about the technicality. What
Yes.
best could be done at this situation?
exactly,
just tell me.
exactly.
So that
If it is
we
a
can
cancer
sort
patient,
it
at
out.
least yes.
Well,
We can sort it out. Okay.
Yes.
Let him read it. You don't bring so many judgment for 205. Medical is very which stage cancer patient?
But oral cancer now, Abhika chemo is taking chemo. But another development is the neurological problem. Another development is there.
What is his age?
Age, I think, but young. I think so. Age is
41 years.
41, not that old.
Young
age.
guy.
Yes.
ଦେଖନ୍ତୁ ଟିକେ ଏକ୍ସାମିନ୍ କର
ଆଜ୍ଞା।
କଣ କରିପାରିବା ଆଜ୍ଞା ଠିକ ଅଛି ୟେସ୍ କାଲି ନହେଲେ ରଖିବା 15 15 ରଖିବା 15
My lord.
କାଲି ଟିକେ ବେଶୀ ହେଇଯିବ ମ୍ୟାଟର କହିଲି 15 tomorrow will be bit heavy 15 14th is holiday 15th okay yes
May I please notice? A discharge petition was filed at the behest of the present petitioner, and that was rejected by the order dated 16/12/2023. Under Annexure 5, the relevant page is 117. It starts.
yes 116
116 is
yes
the order starts. The relevant portion of the order starts from 117.
read it
My lord.
what is your case by the way
My lord, my husband is was a my lord political person and MLA of one constituency, my lord. A DA case was initiated.
your husband
My husband was initiated against him, and in the said DA case, my name crop up during investigation.
109
109
right
and section 12 of the PC Act, my lord. And though there is no material against me during investigation, but they have stated that the income and expenditure of my husband, both of them could not satisfy the investigating authority with regard to the possession of their assets. That's how I have been charge sheeted under section 12 of the PC Act.
and 109 and all okay
109 is not there, only section 12. is there,
Huh.
along with 13(2) reduce 13(1) B of the PC Act. Now,
Then what happened?
I have filed a discharge petition under 239. Lordship may kindly peruse
In that case,
in that case,
which is rejected,
which is rejected.
you are agreed by that.
Yes.
Let us see what is the order.
My Lordship may kindly peruse the order.
Yes.
The
Come to 170.
my lord.
According to Learned Counsel,
Accused
Sujata Panigrahi herself is in income. What is this? Yes.
Lordship may kindly peruse. According to the learned defense counsel, accused Sujata Panigrahi herself is an income tax assessee, and during the check period, she has filed income tax returns showing worth to the tune of 38,44,407 from her legal practice during the check period. The petitioner is a practitioner, my lord. Legal practitioner.
His wife is a practitioner.
Yes. Which she had informed upon the query made by the investigating officer. But the same was not considered without any investigation.
That is your defense. That is 38 lakhs, 44,000 so
My
and
lord.
so is arising out of her own income, legitimate income.
My lord.
Which is reflecting in the income tax
Yes.
return.
Yes.
Is not taken into consideration.
Yes.
This is the whole thing.
That is there. And also,
And how the court takes it, let us see. As submitted by the Learned Counsel for Lokayuk. Come on, page 118. This is your stand. What is the stand of the vigilance? As
vigilance has
read
stated.
118.
Yes.
As submitted by the
Yes,
Learned
my
Counsel
lord.
for Lokayuk.
As submitted by the learned counsel for the Lokayuk, a threadbare discussion is not required to evaluate the evidence whether prima facie case is made out or not. The court has only to see whether there is no ground to proceed against the accused, and if that is so, then the accused needs to be discharged. But in the present case, it is mentioned in the charge sheet in specific in the asset head that Sujata Panigrahi has different bank accounts from where 68,79,001 was found during the check period, along with two immovable properties of 8,20,160.
How will you explain it?
My lord.
How will you explain it?
My lord. My lord, during investigation, my lord, the IO, lordship may kindly come to, my lord, annexure 2, page 19.
Yes.
During investigation, the IO has given a letter to the present petitioner dated 2012-2021, where IO has framed my questionnaire to be answered by the present petitioner. Lordship may kindly peruse that. The total question is 60 in number.
Which question you want? Want me to read?
My lord, he has formulated 60 questions. I have answered all the questions, my lord, satisfactorily.
To your satisfaction, not to the satisfaction of investigating agency. See, you could explain only 38 lakhs 16,468, which is reflecting in your income tax. See the question number 25, page 21.
But 25 answer, lordship may kindly see, my lord. 25 answer is at page 27.
Just come to page
Source of income.
27.
27, page 27. The answer to question number 25. Source of income. Advocacy, consultancy, counseling. A copy of the advocate license.
38 lakhs, na?
Yes.
But see, the allegation are some acquiring property and 68 lakhs.
No, that is not against me, my lord. That is against my husband. In the entire charge sheet, there is no allegation against me, apart from 12 of the PC Act. The entire charge sheet I have annexed. The entire charge sheet is the allegations are against my husband and other co-accused persons.
Who all are the other causes?
In another case where my husband has, my lord, makes a business deal with two of the co-accused persons. That case is also tagged in that.
How many years practice you have?
My lord, 2010.
This case is
This case is 2021.
21 means that time you had a practice of 8-9 years.
21, my lord. 11 years.
11 years.
Well.
You're practicing where?
In Bhubaneswar, my lord.
Where is your income tax return? Where is the return?
Return, my lord, I have not submitted it.
Let's see return.
I will submit it.
Practice and you are filing a return of
Yes,
40
yes.
lakhs.
Yes, I will file it, my
Who
lord.
is going to believe it?
Yes, I will file it before my lordship.
Who is going to believe it?
Another aspect, may I place, my lord?
Hmm.
Your lordship kindly have a glance to the prayer. He has challenged the discharge order.
Hmm.
Rejection of discharge order.
In the meantime,
Now in the
charge-
meantime, charge has been framed and she claimed to be trial.
you
So
have
it cannot be reversed.
I have to amend this petition only with regard to
No, that cannot
that
be.
impugn order, my lord.
No, then revision lies.
My lord.
Revision.
My lord.
Charge against charge
charge
also, my lord.
Revision.
482.
No.
You file a revision. Then counsel for the council in this present petition, the petitioner has challenged the order dated. I don't know which is that order.
Order is
In the prayer you have not written.
16/12/2023.
The prayer at least you should have written 16
12/2023.
passed by.
Passed by the
Lord, special judge, special court, Bhubaneswar.
Special court, whereby his application for discharge under 239 CRP has been rejected. The council appearing for the state for prosecution submits that the meanwhile charges has already been framed. In the light of the aforementioned development, the council of the petitioner submits to seeks to withdraw this petition to assail the order dated
31/1/2023
passed by the court below, framing charges against the petitioner by resorting to the remedy available to him under the court.
But
With this liberty, the petitioner is disposed of.
Much.
30.
In this case, I'm filing.
1 minute, wait. Sir is waiting for some matter.
Item number 49.
49. Sorry for.
I am so embarrassed, my lord.
No, but we can't make you wait.
No, it is wonderful that Lordship has consideration for my age and the younger brothers have.
Everybody has the same feeling for you. There's no doubt about it. Yes.
Lord, this proceeding arises out of a proceeding under section 138 of the Negotiable Instrument Act.
You are accused.
Yes, my lord. Well, your lordship may kindly have a glance at page 32, that is the bank statement where the check is said to have been dishonored, madam.
32.
Page 32.
Yes.
Well, your lordship will see 14th last, my lord, accounts closure. Has your lordship got it?
Yes, 32, na?
Ah.
32. Yes.
Account closed 14/3/2023.
You have closed the account.
Yes.
Check one issued by.
Account was closed, taking a lot on the ground that I have lost the checkbook and also certain signed checks, madam.
Where is the complaint?
Bankruptcy.
You have filed complaint against
police? I have been arrested as an accused in the complaint case.
That's right. You lost the signed check and all. Have you lost any complaint, anything, anywhere?
To the bank, I intimated.
But you have not intimated to the police.
No.
Show me the statutory notice, whether you replied. You have received the statutory notice. Have you said that?
Yes,
in
yes.
the statutory reply? Reply to the notice, statutory notice.
ଅଛି ଯେ ସେ କହୁଛନ୍ତି ଯେ ଇଏଟା କାହିଁକି
response कहीं से जो
Where,
notice.
see, in 138, you, notice might have been given to you.
Yes, yes.
In the reply to the notice, that is a statutory
Have you
requirement.
given-
Have you said these things? If you have not said that, the presumption operates, you have to face it, right?
That is right. True.
Where is that reply? It's not there on record, I've seen it.
Huh?
Not there on record. You file it.
अच्छा.
You bring out, you bring it on record.
बैंक को जो चिट्ठीटा देइछ से चिट्ठीटा को कहीं
All these things have to be brought.
सेटा that has to be annexed ना.
Fine.
बैंक को जो intimation टा देइछ.
Nothing is there on record, whatever he says. Maybe correct, I'm not.
Replied.
हाँ.
The matter should reply this.
Mr. Mohanty, senior counsel, permission to file the additional document to
Yes.
substantiate this case. The message is urgent to 1st March, sir.
That is short date.
Short date, okay. Give a short date. 21st or 22nd, 23rd, something.
Any date that is convenient to us.
22nd. You file all these documents.
Yes.
Yes. Where we left. 22nd. Which item is 30. Yes, 3.
It is.
If you people don't mind, the another senior is also there, we will release him.
I can. Three matters.
No, 3 matters.
3 matters. Again, we had no issue. I'm booked for lordships for today.
The more in this stage, the more the peace.
That is the reason he can wait.
In fact, since my learned senior is there, but this was the tradition of our court also. Earlier, when there was a mention made by a senior advocate for taking the matter out of turn basis, it was being allowed invariably by the courts. And which your lordship did today, Bala.
That I think that is what the court can give to a senior, nothing else.
Yes,
If nothing is there in merit, at least give some.
Yes, exactly. That was happening regularly before.
That should be the tradition,
Yes,
always.
yes.
That tradition has gone away.
But I still
will try to revive as much as possible. All of us have learned things from you.
But I'm reminded
You have
of.
to give it back to them.
I'm reminded of my my learned senior statement once, which fell from him before Honorable Justice Chatterjee. Whether my learned senior remembers or not, I do not know. We were real proud of, in fact, his statement made on that day. The tradition of this bar is as high as any bar in the country.
That's right.
That is what my learned senior has made the statement today, that day.
And anytime goes wrong by court or anybody,
Yes.
it has to be reminded to them.
Yes.
So that we can revive the culture. That's very important. Yes.
Maybe in this case, may I file the application under section 4 to CRPC for questioning of criminal proceeding on the ground of a compromise mail.
Settle. What is the offense?
Offense may 341, 294, 323, 506 of IPC.
Mr. Raghuda? Small offenses.
8,000
5,000
Huh?
5,000 something, my lord, he has not paid.
The only 506 may be non-compoundable.
294.
294. Yes.
Washing. Right now.
60 years old.
At the instance of opposite party number 2, the FIR number so and so came to be registered against the petitioner under section so and so. Okay. You are appearing
Informant.
notice.
Informant.
Advance notice. Advance notice.
Notice was not issued now.
In advance.
So and so appears for opposite party number 2. Opposite party number 2. पूरा नाम मनोज कुमार पति and so appear for madam का नाम appear for opposite party number 2 on advance notice and file वकालतनामा which is taken on record. Both the counsels appearing for the parties conjointly states that their clients have settled their dispute on the basis of the
And Annex 2, my lord, the affidavit filed by the
settled their dispute.
complaint.
They have also filed a compromise, a joint affidavit.
No, my lord.
No, my single.
Only, my lord,
Only the informant.
informant filed by.
The informant, Golok,
Mahagud.
the opposite party number 2 has filed an affidavit dated 22/12/2023, inter alia, stating that they have settled their dispute. Therefore, he doesn't want to proceed against the petitioner anymore. Mr. Ragada appeals state and submit that the offences are minor in nature, and since the parties have settled their dispute amicably, therefore there is no legal impediment in quashing the same, taking into consideration so and so, it is quashed. Yes.
In this case, my lord, initially the case was registered under section 294, 350, 394, my lord. So thereafter, my lord, the present petitioner was in bail by the annexure 3 on dated 16/3.
NBW.
My lord?
NBW issued.
No, my lord, higher offense, the charge sheet is in higher offense.
Oh, Susila Devi.
Susila Devi.
Dispose of
FIR के कहाँ थे?
FIR थिला 294, 350 or 394.
Petitioner
Page
was
9.
suffering investigation. Petitioner was suffering investigation in the FIR, page 9 with one section, so on, so on. After investigation, charge sheet has now been filed. And the petitioner was on bail for the said offences. After the charge sheet, the police have added which provision?
My lord?
364A.
364A, my lord.
364 capital. Higher offense of 364 capital. Capital. Therefore, the petitioner is seeking indulgence of the court, to the extent that the said offense under 364A capital A may be quashed. And a cognizance order, which is the offense under 364 capital A, be quashed. This court is not inclined to interfere with the matter. However, it suffices to say that the petitioner can avail the remedy under law by relying upon the judgment. There are two judgments. Susila Devi, Prabhakar or something. So and seek appropriate remedy before the court below. With this liberty, the petitioner is dismissed. Both the judgment I am writing.
Most probably.
May I please? Order dated 27/9/23 and that annexure 4 was challenged on the ground that, my lord, initially on 14/9/22, the wife of the present petitioner lodged one FIR against the present opposed party, my lord. Thereafter, after 4 months, a counter FIR lodged by the present opposed party against the present petitioner, who is a school teacher, my lord, government school teacher, my lord.
Yes.
And that was ended with a final report that insufficient, my lord. Then after 4 months, protest petition was filed and cognizance was taken, my lord. That is 27/9/2020.
Is there any legal bar?
No, legal, but that's actually that no case is made out, my lord. First, only the counter, I am not present. I am working as a 60 kilometers away. And while my wife is present, they created disturbance, and thereafter a FIR was lodged. Initial first FIR lodged by my wife of the present petitioner. After 4 months, another FIR was lodged by the present opposed party. It is arranging out a complaint case, my lord.
It is only cognizant.
And here annexure 5, same place when, my lord, land was distributed among the dispute arose, my lord.
What is the allegation? Let us understand the allegation. What is the
offense, my lord? 294/506.
That's right, but what is the allegation?
Allegation, my lord, lordship.
You are Ajay Kumar Naik.
My lord.
Show me the relevant part.
Yes, my lord.
There is no illegality in taking cognizance in a
Yes, my lord. In the lordship,
unless you make out a case.
Yes.
That bear reading up for the protest petition complaint and inquiry under 202, no case is made out.
My lord.
Let us see the statement.
My lord, page 24, the complaint petition.
Yes. Stage 24.
My lord.
Yes.
On 5/11/2022.
What is the allegation, let us?
The accused Ajay Naik along with 2 to 3 persons came to the shop and told her to close the shop. When the complainant asked why she will close the shop, the accused abused her in
Read
filthy.
louder. Read louder.
The complainant asked her why.
Page 24 you are reading?
Yes, yes.
Okay. When the complainant asked why she was closing the shop, read it.
My lord. That on 5/11/2022, my lord, at about 6 p.m. to 6:30 p.m., the accused Ajay Naik along with the other 2 and 3 persons came to her shop and told her to close the shop, my lord. When the complainant asked why she will close the shop, the accused abused her in filthy languages like so and told her to leave the shop, and the accused number 1 will let out the shop to others, my lord. When the complainant refused to close the shop, the accused number 1 dragged her from the shop and lay over the road and walked over her and also assaulted her with the intent to outrage her modesty. At that time, her son came and stopped the accused number 1 not to do so. The accused number 1 also abused her son and assaulted her son. When the complainant was lying on her naked stage, my lord, over the road, the accused number 1 brought the iron rod from his house and pressed it to her stomach and told her that you, both son and mother, immediately left that place, else he will kill them, my lord. And after
All
killing,
the allegations are there. What do you need?
my lord, same allegation, my lord, due to insufficient, my lord.
Maybe, but inquiry is conducted in 202.
My lord.
Evidence has come. Cognizance is
Only,
taken.
only because, my lord, they, since your lordship first.
Whether these allegations are right or wrong, I can't take the cognizance stage go into all these things.
Because, my lord, she opened a shop in front of my house, my lord.
You don't understand what I'm saying. The allegations are there.
Yes,
There is no doubt about it.
Yes.
Allegations are there. On the basis of these allegations, the case is made out or not. That's the test.
Yes.
Whether the allegation is correct or allegation is not correct, at the cognizance stage, court can't go into.
Yes, ma'am.
So will you argue all this point at the
Yes.
appropriate stage?
My lord.
Then comes for the petitioner. In this petition, petitioner has challenged the cognizance order dated
27/9/2023.
27/9/2023 in ICC case number 2074 of 2023, whereby the court below has taken cognizance of offence under section
294, 506, 341, 323, 354, 370, and 34 by this.
34 page. Page need you 29. Page 29. Take up. Take up. This court is not inclined to interfere with the inferior order at this stage. And the petitioner seeks to withdraw this petition to read all the points before the court below at the appropriate stage of the trial. With this liberty, the petitioner is disposed of.
Please, my lord. My lord, here my prayer is to quash the NBW because
when you were
I was on bail, I was appearing under section 370 through my advocate due to the communication gap between the conducting advocate with the
submits that he had moved the application.
State has not been made as a party and we have not served copy.
State is not a party.
Not a party. How, my lord, this application is?
Who is there? Nobody is a party.
No, this arises out of a complaint case.
So
Saroj Kumar Swami is the complainant.
So you
NBW should have made the party.
Saroj Kumar
Oh, it's all right.
a complaint case है.
Complaint case. देखो.
पार्टी तो ना बस जो बोल पार्टी को.
His client had moved an application at 317 CRPC. The said application was rejected.
Yes.
Rejected, and NBW has been issued against his client on 2/9/2023 by the court of
Khandapada, JMFC Khandapada.
JMFC Khandapada. He further submits that his client was on bail.
Yes.
Was on bail. So, ये कर दे first mark. On instruction, he says that he may be seek remedy will you want to 500.
Sir, oblige.
500.
ଆମର କିଛି ନାହିଁ
Lord, may I please also?
Yes.
Lord, here is a case where I'm caught between the mid sea and the devil, my lord.
Hmm.
Deep sea and the devil.
Before, well, I may mention, it is a party.
Yes.
The copy is not served to the ED. There is procedure that at the time of filing, copy should be served.
Okay, I'll give copy, and in fact, Lordship may kindly hear me for 5 minutes. I'll give him the copy.
Unless it is taken up, unless the copy is served, it cannot be taken up. I have to take instruction. There is a procedure. Let it come tomorrow, day after tomorrow.
Give your copy by unnecessary.
Well, just now I'm giving in fact, she was supposed to brief me.
There must be a defect.
I know, I'm giving it now. So after the case is over, if he returns, I'll give him a copy today itself, my lord. Yeah. I'll give him a copy.
It may be taken up tomorrow.
He needs an expert injunction.
No.
In fact,
Cannot. I have to go through the brief.
no, well, let me just.
Let it come tomorrow.
ठीक है,
No problem.
Hello, so move on.
Just
Yes.
5 minutes. We will have to accommodate you because you
Yes.
have a genuine. Yes.
My lord, a case got triggered against me and my wife under the PC Act, my lord, for having accumulated, my lord, disproportionate asset to the known source of income.
That in 1 year and all.
Yes.
That is the predicating offense.
Yes.
Yes.
My lord, there on the regular basis, my lord, I was taken behind the bar. I then was enlarged on bail. My wife was also got the favor of an anticipatory bail from this Hon'Ble court. And thereafter, some materials were seized. My lord, some seizure list was furnished to me on the properties being seized, both documents, properties, everything. But I was not handed over any of those documents, my lord. Lordship may kindly come to page 73.
In that predicating offense,
Yes.
it was seized.
Yes.
So we along with the charge sheet, you might have.
No, Lordship may just see, my lord. That is I am just showing to Lordship relevant orders passed by this Hon'Ble court earlier. Lordship may kindly comes to page 676.
Yes.
This was an order passed by this Hon'Ble court on 29th of October 2021 by my wife. Heard Sresas Das and Mr. Maharana. This application under
name from the FIR.
Yes. This application under section 482 has been filed by the petitioner seeking deletion of her name in the FIR filed in connection with the Bhubaneswar vigilance case number so and so. Pending before the Lawrence.
It was given to you to raise all these things.
No, Lordship, this is para 4 is very important.
Yeah, that's why.
Well, this is what is being not done by the ED now at the moment. This is being done by vigilance now. Well, what is Lordship can just see para 4 once again.
After hearing the responsible bodies and view of.
Lordship can come to 6th line from the top.
It is directed.
It is directed that the IO shall.
The explanation.
Yes.
Documents has been furnished by the so. That is in the
vigilance case.
Predicating court.
Yes, well, that is they are doing, my lord. But so far, charge sheet has not been filed, my lord. They are doing. Periodically, they are.
What is your given?
But now,
not the same order. Same order in so far as PML is concerned.
Yes.
That's the
yes, if that happens.
Yes, my lord.
Just see page 76. It's in order without prejudice.
Page 76.
This is 76. Paragraph.
And
we can dispose up with the same.
Yes. Otherwise, I could have gone to merit in by saying section 2, subsection 38 of the Malad.
This is an order of this court.
In predicating offense, whatever defense he has, they say that you raise all these things before IO, I will take into consideration.
Yes, difference is different. Schedule offense and PML offense.
No, but if he says something, why can't you take into
There is no provision that the accused will submit a representation, the honorable court will direct the representation to dispose of.
It's not
now he should
representation.
face the proceeding.
There is a legal.
Now,
no, he will face the proceeding, of course.
now thing is that.
It's a kind of confiscation.
Well, today no order can pass. Now only thing the matter will be taken up so that I will detail.
Yes, of course, no problem. But to that extent, you seek instruction. We can dispose it up saying that, see, he is rendering some explanation. Ultimately, he has to show you whether it is flowing from the legitimate income or not, or it is what are the expression used in PMLA?
And one more.
Proceeds of the crime.
Proceeds of the crime.
Malad,
That has to be seen. If he can show, in any case,
Malad,
yes,
very clear. Section 50 is a civil proceeding. That proceeding will continue in the department.
First of all, he should be.
So a summon will be issued to the party to explain.
Now you
the
simply
source of-
say what is the prejudice if this kind of orders are passed.
No, I do not know.
482.
What is the nature of the application? Let it come to day after tomorrow.
No, I will
Yes.
adjourn it, no problem. But you seek instruction in this light that I think this is a no prejudicial order.
Well, again,
He is rendering some explanation. You take into
Well,
consideration.
again,
Explanation, yes. That I must say. Yes.
Yes.
well, again,
Explanation already opposite has been given. Annex that the annexure 10. Annexure 10, I think it is a notice under.
PMLA.
Lordship, let's see page 82, Ballad, because he is not gone through, he just
Yes.
Now he
not
is
hovering around, he's just hovering around the documents.
Yes, yes.
Lordship, just his
Yes.
page 82, Ballad.
Yes, madam. It is a proceeding under section 50.
Well,
Section 50 notice is a civil proceeding. It has been issued by the assistant director. He is now already given an opportunity to explain all this.
No, it
source
has
of
not
income.
been given. Lordship, just sees page 82 and page 84.
Let it
It's
come
an
down to-
order of this honorable court.
Yes.
Order of this honorable court, what was submitted by the PMLA, Ballad. I mean, from the department side. Mr. Gopal Agarwal, Lordship with me, Ballad,
Yes,
at page 84. This is the order dated, Ballad. It starts from page 82. Order dated 12th of January 2022, Ballad. Page 5, I mean, para 5. Mr. Gopal Agarwal, Lawrence, counsel for the opposite party number 3 submits that the challenge to the summons and the proceeding at this stage is premature, as the summons in exercise of the powers under section 50, subsection 2 and subsection 3 of the PML Act has been issued for the purpose of inquiry and investigation only, and the petitioner is not an accused in the case. He should therefore have no apprehension of being arrested on his appearance before the OP number 3 in response to summons filed in Annexure 2. A complaint under section 44(1)(b) of the PML Act will be filed against him after examining the material available against him. The petitioner is yet to submit the copies of the documents sought for by the OP number 3, although time has been taken. Well, these copies were seized by the Vigilance Department, for which this honorable court directed the Vigilance Department to supply me the copy.
You seek instruction in the light
Yes.
of.
Yes.
I'll
I will
just,
take instruction.
I'll put it on, which date you tell me? Which date?
Yes. So, on next Monday.
Next one, 19? 19.
Hmm?
19.
Yes.
19. Next.
But Lordship, can it be 26th, Ballad?
Yes.
26th.
Twen-
Give a copy there.
Yes.
Yes.
Okay.
But in the light of
In the course of.
whatever he has said-
Don't worry.
whatever he has said, in the light of that, you seek instruction.
Yes.
Who will dispose it
Certainly.
up?
There is a order, whether it has been compared with.
Because there are 2-3 orders.
Yes.
If there are orders, then we can follow that order and pass.
Certainly.
Yes.
May I please? Here the petitioners filed this application challenging the initiation of criminal proceeding and commencement of the same.
Because you have not got bail.
Here the petitioners are the in-laws members of the OP2 Your Lordship. The petitioner 1 is the brother-in-law, and the petitioner 2 is the sister-in-law, and the petitioner number 3 is the mother-in-law, widow mother-in-law.
Of opposite party number 2.
OP2 is the wife, Your Lordship. Here the case, Your Lordship,
No. What is this case is about?
they have initiated the DB proceeding, section 12 of the PWDB Act, Your Lordship.
Where is the TV proceeding case?
Annex 1, page 8 is the
That is the.
notice the petitioners have been
Okay, but
received, Your Lordship.
where is your complaint?
This is the complaint, Your Lordship, report from the domestic incident report, that is by the protection officer, Your Lordship.
But there must be some complaint she might file section 12.
No, my Lordship, this is the we have received, this is the format complaint, Your Lordship,
Where is that?
with affidavit. That is Annex 1, Your Lordship. My humble submission, Your Lordship, the fact remains the marriage took place on 6/5/2019 and 10/12/2020.
What is the relief she has asked before court below?
My lords, relief she has asked for a lordship as page 15 a lordship.
Come to page.
In the application form, all relief he has put right mark a lordship. A lordship kindly have a glance at that is the form 2, page 15.
15 years.
Yes, the para 2 lordship protection under order under section 18.
Protection 18.
Yes, section 19, section 20, and section.
Everything. Okay.
Yes, all this relief
Now, what,
is sought for.
why, how are you aggrieved and why the court should enter that?
Yes, my the petitioner's prayer lordship. There is no specific allegations against the present petitioners in the incident report, or there is no specific relief against the present petitioners in the incident report.
All these reliefs are there.
All these relief,
Residence and all.
but so far the relief sought for how the from the present petitioner lordship, that is not specified in the petitioner
We
lordship.
don't know whether it is a joint family or separate, nothing is there on that.
The separate lordship.
How do you know?
That is the
How do you know? Show me from record that you are staying separately or something.
that is I avoided my petition as well as your lordship with the after filing of civil proceeding before by the husband and lordship, after disturbance your lordship, the husband and wife, they are residing separately from the present petitioners, and now this domestic violence case has been.
Any maintenance is awarded by the.
No, my lordship, that is pending. That is pending before the learning court below, lordship.
That's the problem. We can't see it.
It's a case where someone has been issued. Let them to
Matrix-
appear.
No, you appear.
And evidence will be taken up care of.
No, my lordship, your lordship,
Someone you have come.
my lordship,
Appear and tell all these things to the court below.
but your lordships know the position of law by the Honorable Affairs Court in lordship. If there is no specific allegation and there is no specific relief,
Specific
The,
relief has been sought for.
though
Relief is sought, allegation is a format.
It's a format.
Where from you get the allegations?
Unless
You
until the
never-
evidence is taken off.
You
the
put tick mark and file it.
Yes.
Someone's are
No, this is the
Hey,
procedure.
this is the procedural
So
lordship.
therefore, how will you elucidate from the record?
Exactly.
That what is the heck? You have to go and tell,
Yes.
I am staying separately, I have nothing to do with all this thing. And this 482 court can't examine everything on the basis of two annexure.
Two annexure and
one
the-
summons and how can you decide?
That is the formative lordship under the law and she has lost. The prime facie material lordship before the court below this formal lordship. And basing upon that formal lordship, the court will proceed.
It is only a summon, you can.
It's
go
a
and tell
procedure.
the
No,
court.
only-
It's not, heaven is not going to fall.
Yes.
You go and
No,
tell.
sir,
Writing to the
without.
High Court immediately at 482 in the summons says what is this?
No, only when the unnecessary the present petitioners will be dragged to the court of
What to do? The
law.
matrimonial dispute that. the
ଆପଣ ତ ହଜବାଣ୍ଡ ବିଲ୍ ତାହା ଲେଖିଛନ୍ତି
ନା, ଆମେ husband ନୁହଁ।
ରାଜେଶ ପଣ୍ଡିତ
ଆମେ husband no,
you are the in-laws members.
in-laws members.
So ତ
Husband
resident
wife-
କ୍ଲେମ କରିଛି ରେସିଡେଣ୍ଟ ଆପଣଙ୍କର ତାଙ୍କ ଆପଣ
ତା
ଯୋଉ
ମିଶିକି
ଜାଗାରେ
ରହୁଛନ୍ତି
ରହୁଛନ୍ତି
କି ଅଲଗା
ସେଠି ରହିବେ ସେ ଗୋଟେ
ରହୁଛନ୍ତି,
ପାର୍ଟ
କେମିତି
ରହିବେ
ନାଇଁ,
So
ସେ
that
ଜଣେ
is
ରହୁଛନ୍ତି
taken care
ତାଙ୍କ
of in the evidence.
parent
Where from I'll get all these things, sir? I'll presume everything, whatever you say is correct, so therefore I have to quash it.
no, my lordship, your lordship after notice the OP will appear and say.
Simply issue notice letter. But this is not the stage where you resort to 482. You should have gone there.
That is the view of the Honorable Affairs Court of Lordship knows the.
View,
So 20
view at the threshold. Which
Threshold.
court has given that view?
Your lordship,
At the threshold,
2020,
it says if there is no material, there is no relief.
my lords,
There are many relief. Which
No,
relief is attracting you? How do I know? How do I know?
No.
He has asked many relief.
yes, but from the record of lordship, tick marichi se, ସେଥିରେ ବି ସେ specific
Format.
କଣ କଣ
Format. What can I do?
କଣ ହେଇଛି all mark your lordship against the husband and lordship, sexually exploited.
Is it in the, show me. This is against husband, this is against, where is it written?
Page 11 lordship kind
Where
level.
is that? The tick marks, just show me.
पेज 11 लॉसिप दया करे निम्न पदत स्थान रे विवरण उल्लेख करंतु ता आगे देखंतु
Sir, come to 15. Come to 15. Page 15. Pass protection order under section 18. Pass residence order under 19.
Yes.
Direct the respondent to pay money in the relief of section 20.
So
Pass
that
the
is-
order under section 21 of the act.
that is
Direct
confined
the
to husband and
respondent
lordship.
compensation damage under 22, pass such interim orders, everything she is asking.
That is against husband, also monetary relief, your lordship, against husband.
There is no point delving upon all the things now.
Lordship, may notice.
Simply issue notice. March, April and May. Unnecessary, you are keeping it pending. You could have gone and argue and finish it up there. Anyway, yes.
Obliged.
115. 18 matter. We don't know how much time they will take. And there is other meeting also. Yes.
Obliged.
36. The petitioner challenged the order dated 2/12/23 passed by the additional session judge, my lord, rejecting the annexure 1. The lordship turned to page 7, my lord.
What is that annexure 1?
Annexure 1 allow the application by the subdivision magistrate Chhatrapur, my lord, on dated 5/1/2023, since the electric pole of 11 kV line, my lord, exists on my land, my lord. I have approached to shift it somewhere, my lord. Thereafter, my application was allowed. That electric pole of 11 kV line exists on the land of the petition number 1, which caused a lot of inconvenience and problem to the petitioner as well as the inhabitants of the locality due to the existing 11 kV line electric pole also causes danger to the petitioner as well as the other
There is
inhabitants
a
of the.
direction to the executing engineer.
Yes, my lord.
Then
He, by way of revision, my lord, he has approached the additional session judge Chhatrapur. He, in his order dated
What does-
2/12, my lord,
what does-
technically he has rejected my application.
it is 133.
Yes, my lord.
You are
I am
you
the,
are only agreed. Nobody else is agreed in the locality.
yes, my lord. In my land, that pole was 11 kV line was there.
Yes, Mr. Kumar.
Melody, last may kindly turn to page 6. Para 8. Yes, you got it. Page 6, para 8.
Page 6 is the affidavit.
No.
Which one here?
ଆପଣ ଦେଇଛନ୍ତି ଯୋଉ ଜଜମେଣ୍ଟ ଦେଇଛନ୍ତି ସେ ଜଜମେଣ୍ଟ ର ପେଜ 6 ଆଉ କିଛି ପେଜ ଦେଇନାହାନ୍ତି
Annexure 1, 2 ଦିଆ ହେଇଛି ନା?
କିଛି ନାହିଁ ପେଜ 2 ରୁ ଜଜମେଣ୍ଟ ଷ୍ଟାର୍ଟ ହଉଛି ଅରିଜିନାଲ ଦି ଜଜମେଣ୍ଟ ପେଜ
ଓହୋ, judgment, internal page.
my lord
On where reading?
yes page 6 the judgment page 6 not the running page judgment page 6 para 8 I have gone through. There are two documents required. One is the RI report and one is the gazette notification. So now I am
Submitted by
so that has not been filed in this application. So now I am going to that my lord order. What conclusion arrived by the London Session Judge?
I have gone through the gazette notification submitted by the London Council for the petitioner, published on 20th February 2009 of the Energy Department.
There are some worry that those things that has to be seen.
Nothing. Two dependent important documents required. One is RI report. One is gazette notification.
Gazette notification I will file, my lord.
That both the documents have not
Next
been
week I
filed.
will
in this
file.
application.
Seek time to file additional documents to substantiate his case. He may do so within 1 week.
Date may be fixed, my lord, on 19th or 20th.
19th, 20th, we will see. Every day 80 matters, how can I handle? Just see.
21st असतो तर.
We have 36 item now. 80 matters.
नाही मग डॉक्युमेंट फाईल करू ऑन 21st your lordship keep it
For
on.
your information, I'll tell you during lunchtime also we have meetings and all. We don't
Obviously.
have even 10 minutes to breathe.
Your lordship fix a date, otherwise I.
So the date of the date.
May I please, your lordship? Here this application, see my 311 petition was rejected. I have approached the Hon'Ble court, my lord, to recall the PW 3 and 4, the mother of the victim and the victim, my lord.
Foxo.
No, I will. Huh? Today.
After launch. Hon'Ble. Any other mentioning for adjournment? Mentioning, no mentioning. You have any?
Number 40
Yes.
matter.
Huh?
Item number 40, Belgium matter matter.
No, matter will be taken up. Any adjournment? You tell me.
adjournment ଯୋଉଟା ସେଇଟା mention
63, item number
63.
63.
Adjourned.
73, 75.
63 and 73.
75, my lord.
75. Tell loudly, otherwise other matters will be adjourned.
My lord,
60?
63, 73, and 75. Not sure.
my lord, item 58 is sub item is a different matter, my lord.
Those things you tell. Adjournment you tell.
39 টা on Thursday.
39 would have.
Thursday. Oblige.
Bimal Morana. Nirmal. Abhishek. Nigamananda. The parties have settled the issue. Have they filed a joint affidavit or something?
My lord, joint application.
By the
At
opposite party number 2, who is the informant only injured, they filed an affidavit. Affidavit dated 15/9/2020.
Right,
In the they are taking that is with the petitioner.
They have not filed joint affidavit. Informant file affidavit.
Informant is filed. On the intervention of the well-wishers. He doesn't want to proceed with the matter, proceed with the prosecution against the petitioner. The petitioners, as well as the opposite party number 2, is represented in the court, represented by the respective counsel. They have also filed their self-attested copy of their Aadhaar card to establish their identity. Mr. Pratap, feeling for the case submits that although offense under section 307 is invoked in the present case, however, the medical report, the injury report indicates that the injury sustained by the opposite party number 2 is simple in nature. Simple in nature. Since the party, since the opposite party number 2 has already entered in a settlement with the petitioners, so as to maintain peace and tranquility in this area, he doesn't want to proceed with the case. Therefore, there is no legal impediment in causing the subject matter. Taking into consideration the aforementioned factors, and you have to pay. Who are the petitioners have to pay cost?
Lordship may kindly record that the injury report was filed by the petitioner.
Injury report is filed. Injury report, certified copy of the injury report filed by the petitioners. Petitioners are taken on record.
No, that's taken. Obliged.
Okay. 500 each. Hey, 1,000 each. 307. You pay. How much you pay? Cost.
3 accused person.
Huh?
3 accused person.
3 accused person. Then
1,000. 1,000.
1,000 each.
Each.
500 each.
500. 500.
Okay.
Huh.
No.
Item 7. Yes. Adjourned.
May your lordship, here the petitioner challenging the ten. NBW order dated 21.
When you have bail,
No, my lord. It's a my lord absconder NBW, and prior to submission of charge sheet, my anticipatory bail was not inclined by this honorable court, and given that number, my lord, that is my lord ABLA PLA number 2334 of
it was
2020.
rejected.
Not inclined. Since I think
You were absconding.
absconding. Then my lord charge sheet submitted on my lord 30/11/2022, and Lawrence Court below my lord took cognizance of the offences my lord on 21/2/2023 against my lord near about 20 persons, and accordingly issued NBW
By order dated 21/2/2023, the land court below has taken cognizance of the offence against as many as 21. As many as 20
Yes.
accused persons. 20 accused persons.
all are in bail.
All are on bail except the present petition. Petitioner's attempt to get anticipatory bail yield no result. Because since the petitioner was not present in the court on
Not present.
NBW on
NBW on the same day.
21/2/2023. 21/2/2023, NBW was issued by the court of SGM. Rajput. He seeks indulgence of this court and the state. On instruction, the counsel for the petitioner submits that his client would be appearing before court on or before 29th of February. 29th of February, and seek remedy is available to him under law. Taking into consideration the aforementioned facts and submission at the bar, the NBW issued against the petitioner by order dated 21/2/2023 by the court of SGF. So it kept in abeyance till 29th February 2024. So as to enable the petitioner to surrender before the court below and resort to the recourse available to him under law.
One more prayer, my lord. Since one of the offences is the 307, my lord may directed both the courts below dispose of the bail application on the same day. My lord, otherwise, my lord, since it's a case, my lord.
Otherwise you will go to jail.
Yes, my
That's
lord.
the only other.
In the other hand, my lord.
438 you couldn't get. 482 this much I am giving. I stayed your NBW. Go and take remedy. You know,
1 million only in case in
29th you are free.
Yes,
You can do
my lord.
whatever.
In case of rejection, the petitioner may approach higher firm. This much, my lord.
In case of rejection, in any case you will come to there.
Only
When
this
you
much.
come, you are this.
No, not any this much, my lord. In case of my lord.
Only relief what I can give you.
Yes, my lord, that
Since
is
I am not costing NBW, no cost is given.
no cost if since my lord 307.
No cost is imposed.
Otherwise cost.
Cost my lord, gotti
I am
antecedent.
not costing it. I am keeping the events.
Yes, my
So
lord.
therefore, I am going to do. Yes.
My lord, only 1 million. In case of rejection, approach higher forum.
Don't use this jurisdiction. 21. 21. Yes.
My lord, challenging the order taking cognizance, my lord, dated 6/10/2023. My lord, here the petitioner number 1 is the mother, 2 and 3 are sons, and the informant is the elder son. Case is the
Mother is 90 years.
Yes, my lord. And the case posted by the informant is that
But 420 and all, huh?
420. ଯେ ସେମାନେ କହୁଛନ୍ତି ଯେ ଲ୍ୟାଣ୍ଡ ଆକ୍ୱିଜିସନରେ ଟଙ୍କା ପାଇଥିଲେ ସେ ଟଙ୍କାରୁ 5 ଲକ୍ଷ ଟଙ୍କା ତାଙ୍କୁ ଦେଲେ ରେଷ୍ଟ ଆମାଉଣ୍ଟ ଦେଲେନି ବଟ୍ ଇନଭେଷ୍ଟିଗେସନ ଡଜ୍ ନଟ୍ ଡିସକ୍ଲୋଜ ଦ୍ୟାଟ୍ ହାଉ ମଚ୍ ମନି ଇନ୍ ଲ୍ୟାଣ୍ଡ ଆକ୍ୱିଜିସନ ଦେ ହାଭ୍ ଗଟ୍ ଆଣ୍ଡ କେବଳ ଖାଲି କହୁଛନ୍ତି ଯେ 5 ଲକ୍ଷ ଟଙ୍କା ଦେଲେ ନାହିଁ ନାଉ ମାଇ ଲର୍ଡ ଇଟ୍ ଇଜ ଏ ଡିସ୍ପ୍ୟୁଟ୍ ବିଟୱିନ୍ ଫ୍ୟାମିଲି ମେମ୍ବର୍ସ ପିପଲ ଲର୍ଡସିପ୍
Who is the informant?
informant is the elder son
ପାଟି କରୁନାହାନ୍ତି?
ନା ନା ପାର୍ଟି ଷ୍ଟେଟ୍ ଅଫ୍
ପାଟି କରନ୍ତୁ ଫ୍ୟାମିଲି ସେଟଲ୍ କରିବା ପାଟି ତ କରନ୍ତୁ
Dispute is mother and son, my lord.
Mother and son.
and permitted to.
But I want to stay the proceeding against the mother. 90-year mother by son, what is this?
She কইছেন যে 420 allegation
Whatever
against-
called the mark against the 90-year mother. Dekho, the petitioner is by what is this? Cognizance order.
Yes, ma'am.
Petitioner has challenged the order. The petitioners have challenged the order dated 6/10/2023, passed by the JMFC, Dasapallu, whereby offense, whereby the cognizance for offense under section so in revenue page 22 was taken by the court below against the petitioners. The case is initiated by the elder son of the petitioner number 1. Elder son of the petitioner number 1. The other accused persons, namely petitioner number 2 and 3, are the brothers.
Brothers.
Are the brothers up to the informant. Legal counsel for the legal counsel for the petitioner seeks liberty to implead the informant in the present case as opposite party number 2. He may do so during the course of day in the court. Countersign issue notice to the opposite party number newly added opposite party number 2. Mr. Ravada appears in the in the next step. I hear that in the meantime, the proceeding before the court below in PS case number 7, phase 2, application of phase 2 is state will further they do mark. Try to settle and finish it up. Revenue with report. Service code. First you implead them. Now take the notice and abstain the product. Yes. 40. Yes.
Belgium matter, the petitioners are earlier on bail by the annexure 1 matter.
Tell the date. Tell the date when you got bail.
Matter. Washing up NBW matter.
FIR.
FIR matter. NBW passed due to non-present in the court. Earlier on bail. The petitioners are earlier on bail by the annexure 1 matter.
When you got the bail? 18/3/2020.
Yes, my lord. Yes.
NBW
passed on
15/5/2020.
15/5/2020.
Pay 500 cost. Cost.
Madam.
500 cost.
Madam.
Yes. 38. Gotcha. Yes.
May please your lordship. NBW was issued against the petitioner on the
When bail, you tell me the bail order.
bail order. As per the petitioner were released on bail, petitioner number 2 released on bail 8/4/2022 and petitioner number 1 on released on bail 11/4/2022.
जोर से खोल दो.
Petitioner number 2 released on bail on 8/4/22.
8/4/22.
1 released on 11/4/22. As per the honorable High Court.
NBW
NBW
1/11/2020.
1/11/22.
What? 500 each.
Oblige.
Yes.
Belgium matter at page 6.
Bail, you tell me.
28/8/2023.
Bail.
In fact, the prisoners all were on bail. Here the prisoners is only.
When you got bail, you tell me.
Exactly. I stated only throughout on bail.
The petitioner was on bail. NBW 28/8/2023. 500.
Yes.
Yes.
42. May I please, Lordship? Lordship, the petitioner is on bail, released on bail on 24/8/11.
24/8/11.
And NBW issued on
13.
3/9/13.
Where were you?
Lost,
For such a long time.
he is always attend the court, but on the said date on.
No, the NBW was issued in the 30th September 2013.
Yes, my lord. This is not in the knowledge of the petitioner.
1,000. 1,000 you pay. And appear before the court on or before 29.
Yes, madam. Oblige, madam.
43. 43 for quashing of the proceeding initiated by the OP number 2. My lord, marriage in the year 2000. She left the house.
What are the offenses?
Offenses 498A, 498A, 323, 352,
Have you
340.
drawn up any proceeding for separation and anything?
No, my lord. What has happened here? The husband has become mentally ill since 2018.
After marriage?
Marriage 2007. 2018, he became insane. So he is undergoing treatment. I have filed all the documents. Your lordship may kindly turn to
Are you suggesting he became insane because of
that is, my lord, that is there. Your lordship may kindly turn to annexure 3 and 4. That will show the father-in-law, the letter written to the father-in-law and mother-in-law. Page 43.
Yes, having on that.
Yes.
This is the dated.
The 31 May 2022.
What does she say here?
My lord,
I'm staying in my parents' house and since last
Yes.
8 to 9 months.
And-
Things are well known to you. Who is
my lord,
he is right? She is writing to
Papa, Mommy. Papa, Mommy means father-in-law and mother-in-law.
Okay.
Next.
I wanted to let you know
My lord,
that
next.
I have asked my husband to give maintenance for me. Yes. Next is?
Next, my lord, page annexure 4, page 44. Yes.
What does she say here?
She said, I see that in spite of my several requests, my husband didn't give me anything, but you have given me such amount and keep on giving me such amount. And in fact, every month, 30,000 rupees is being paid to her by the father-in-law because 2 hotels are there. Father-in-law is having 2 hotels and it is under a company. So they have decided to give everyone is having a share. Father-in-law, mother-in-law, and 3 sons. Whatever share is being paid to the husband of the petition, opposite party number 2, 50,000. Out of 50,000, 30,000 in every month is being paid to the informant. And
out of the share of the husband, her husband. 50,000 husband?
50,000 out of 50,000, 30,000. And my lord.
What does she say in the FIR?
FIR, she said many things that I have been tortured since 2007. Since I have been blessed with 2 daughters, and they have told that they are unauspicious, like that, many things. And 307 allegation was there, but it was found during investigation that
Sanjay Kumar is the husband.
Sanjay Kumar
Who is insane?
Insane. Your lordship, I have filed all the documents.
And Bela Singh is the
Singh is the mother-in-law.
And
Sahib
Singh, Lal Sahib Singh.
Lal
is,
Sahib, yes,
father.
yes.
Yes, pathetic.
Notice Vasant.
See, insofar as one is concerned, he is insane, he can't face the trial, what is the use of it? And I am always of the view that in the fight between wife and husband, why the parents will be suffer? Parents are already, and moreover in this case, the girl is writing letters that you have been doing no allegation. There are 2 letters which she read out.
Yes, sir.
It indicates that they had a courier relationship. And thereafter, arm twisting.
And they are also staying separately since 2013. Because she could not manage.
But under the garb of stay or this proceeding, I believe you will not stop whatever you are paying because there is.
No, I am not. My lord, irrespective of anything, every month I am paying. Every
How
month.
much you are paying?
30,000 every month.
Has she filed any interim maintenance?
No, my lord. She has filed a DV case. DV case is pending. She is not appearing after filing, and this is also arising out of a complaint case.
देखो जी, the petitioners have filed the present petition in quashing of the entire proceeding arising out of 1 CC case number 617 of 2022, which is subsequently converted to Shauliaganj PSC case number 160 of 2023. This present case is initiated by the opposite party number 2. Petitioner number 1 is the husband of opposite party number 2, whereas petitioner number 2 and 3 are the in-laws of the opposite party number 2. Ms. Sudhakar, appearing for the petitioner, submits submits on the basis of the document placed on the record that the petitioner number 1 has become insane since
2018.
Since 2018.
And undergoing treatment.
She has also taken me to the annexure. Annexures.
5 series.
Handwritten annexures.
Yes. 3 and 4.
Handwritten annexure 3 and 4, which are the handwritten letter written by the opposite party number 2. To the petitioner number 1 and 2 and 3. Petitioner number 1. Reading of those letters indicates that she had a cordial relationship with the petitioner number 2 and 3, and she had no grievance against them. However, the complaint case is subsequently filed against subsequently filed by the opposite party number 2 against the husband and in-laws. Mrs. Sudhakar further states that despite this litigation amongst the parties, the petition number 2 and 3 have been paying maintenance to the opposite party number 2.
Rupees 30,000.
30,000 rupees
every month.
And she says, further states that without prejudice to the right and contention, of either party, her client would be continuing paying the maintenance to the opposite party number 2. Issue notice to opposite party number 2, written within 2 weeks. In the meantime, the proceedings pending before court so is stayed till further.
Obliged.
Yes.
My lord, matter related to Belgium, my lord.
Yes. Wait, when you got the bill?
On 13/12/2023.
13/12/2023. No, that is NBW issue.
Yes, my lord.
When you got bail?
Well, in 2021, my lord. 28/2021.
28/2021.
Yes, my lord.
Bail 2 and 2 है, ये 23. Okay, 500. Was next.
35, my lord, Belgium matter. Petitioner was on bail on 16/4/2014.
And NBW?
NBW was issued on 4/9/2023.
500. Yes.
Obliged.
56.
Belgium matter, my lord.
Yes.
NBW dated 9/1/24, my lord.
Bail.
Bail, my lord, 22/11/21.
22/11/21.
NBW 9/1/2022.
9/1/24. 500. Okay, how many of you are?
1.
500. 57.
Same Belgium, my lord. The release on bail 10/1/2018. NBW issued on 16/12/2022.
500. Yes. 58.
OTD also Belgium at Annexure 1, page 6. NBW issued on 9/11/2020.
Bail, when you got bail?
That is to get
That you don't
back throughout on bail, but exact date.
petitioner was on bail, लिखते ना? 9/11/20.
Yes, sir.
Check the file. Don't write like that. One of you, 1,000.
Yes, Lord, sir.
Yes. 50.
Yeah, please, Lordship, challenging the imbue order dated 7/9/2019, Your Lordship. Bail allowed on 31/10/2016, Your Lordship.
2016.
Yes, Your Lordship.
In 19. How many of you are there?
Due to the communication gap between the council and the petitioner, Your Lordship.
500. Yes.
Oh, please, Lordship.
One.
Lordship, pardon, Lordship, 5,000.
You want to pay?
Sorry, Your Lordship, I have 500.
500.
You want to pay a little more, it seems.
Sorry, Your Lordship.
You are mentally prepared to pay 5,000. So you are agreed by that.
Pardon, Your Lordship.
Yes.
May I please, Your Lordship, my lord. The petitioner in this case, my lord, filed for the passing of the entire criminal proceeding, my lord, because the dispute in civil in nature has given the color of criminality, my lord. From the bare reading, the FIR itself shows that the dispute is of civil nature, my lord. But the agreement.
What is the stage of the investigations?
Investigation going on.
Wait, I'll just simply adjourn. How much time will you take?
My lord,
How much time will you take?
it is listed on 29/8/2023. It's a case under section 420, 467, 468.
Let the investigation over.
I have the decision, my lord. Or
No, I will not issue notice. There are two options. Either I'll dispose it of saying that reserve your right to challenge at the appropriate stage, or I'll simply adjourn to April, so that meanwhile they will complete and tell the court. April. लिख दो इसमें. The petitioner has filed a presentation seeking quashing of the criminal prosecution initiated against him. Against कितने लोग हैं? Initiated against him. The investigation is still on. Still on. The FIR was lodged on 29/8/2023.
Yes.
Mr. Maharaja appealed for the state and submits that since the investigation is on, no interference is called for at this stage. The matter is adjourned to potential state, awaiting the outcome of the investigation. Shall I dispose it of? So that you will come?
not how. Oh, because it will be before my lord. I am ready otherwise.
Yes.
May it be, Your Lordships. So Belgium Metro, Lordships, 19/1/2024.
How many matters are there?
One matter, Lordships.
Bunch of matter you say?
Item 52.
You say bunch of matters?
No, Belgium matter.
Belgium matter, okay. When you were on bail?
19/1/2024, NBW has been issued.
Yes. Bail?
Bail, Your Lordships, on 24/12/2012.
12?
24/12/2012.
12/2012. Okay. NBW is on?
On 19/1/2024.
500. Yes.
Well, in this case, Your Lordship may direct the petitioner.
My it was fixed to date, man.
Date will be fixed.
16th April. Your Lordship may kindly say this item number 52. The judgment is in seal cover. Let him to appear at least on the date, so that the judgment can be pronounced.
Oh, judgment is at this stage you have not gone.
Yes, yes,
Okay. Right down. 52, na?
Yes. 52, my.
Item 52 report. Mr. Maharaja appears for the state and submits that in this case, the final argument of the case has already been done, and the judgment is kept in the seal cover to be pronounced.
Yes.
To be pronounced. Next date appearing?
The date on the let him to appear so that the judgment will be pronounced.
The petitioner, on instruction, undertakes before this court that his client would be appearing on the next date appearing, so that the trial court can pronounce the
Judgment.
Subject to the aforementioned submission made by the counsel for the petitioner at the bar, the NBW is
Satisfied.
satisfied.
Yes, yes.
Satisfied?
And the petitioner is directed to appear on or
And the
before.
petitioner is directed to appear on or before 29th of this month to this normal thing. Yes.
53. May I lordship, please. My lord, this is the Belgium matter. And he was released on bail 9/8/2018. And NBW issued 8/11/23.
500. Yes.
Yes, my lord.
Next.
500.
Here.
My lord, 54 and 55 may be taken out together, my lord.
Yes.
Arising out of the same my lord, doctrines. My lord, they both are, my lord, the employees of iCare company, my lord, who manufactures Royal Enfield, my lord, motorcycle.
Okay.
My lord,
Sagarika Chaudhary and before
Sagarika Chaudhary and my lord, Kaushik Basu.
Yes.
My lord,
Which one you are referring to now?
My lord,
54 or 55?
my lord, 54.
Okay.
Sagarika Chaudhary, my lord. My lord, before lordship looks into the file, my lord, just 1 minute I can explain, my lord, to your lordship. My lord, this complainant is arising out of a complaint case, my lord. This complaint's land Sipra Roy, my lord, is the sister-in-law of the proprietor of a particular proprietorship concern, which was a dealer of, my lord, Royal Enfield motorcycle. And we are the employees, my lord, of the iCare company, motor vehicle company, which manufactures Royal Enfield motor vehicles, my lord. Cars, I mean to motorcycles. My lord, there was an agreement between iCare and, my lord, the proprietorship concern, wherein the complainant was an employee. As the sister-in-law was the employee there, my lord. And because of, my lord, lot many irregularities done by the proprietor in selling the motorcycles, in, my lord, collecting the, my lord, purchase orders, a lot many irregularities. For which reason, my lord, the Royal Enfield cancelled the, my lord, dealership.
As per the terms of the contract.
Yes, yes. By adhering to a clause in the contract, the contract was cancelled. After the, my lord, it was, so when, my lord, the contract is cancelled and it is made public, my lord, obviously there will be no further buyer going to the, my lord, dealer, the astral dealer, to inquire about the vehicle or to book any vehicle for that. Well, because of the cancellation, well, what happened? One of the, my lord, intending buyers of bullet motorcycle, as the story goes, had been to the dealer to inquire about his booking. He had booked a motorcycle, my lord.
Right.
And booking was with somebody else, not with this person. This dealer. If the booking was with somebody else, why should he go to this dealer, my lord? Then when he wanted to, my lord, inquire about the whereabouts of the booking, then he was, my lord, dealt with in a manner which is not acceptable, for which the allegation is that he also had an altercation with that lady. And because of the altercation, my lord, then she lodged an FIR before the local police station.
That buyer.
No, that lady.
That lady.
Lady.
Whom altercation took.
Yes. And since the police did not, my lord, find any cognizable offense being made out, and apparently also did not seem to have been, my lord, a genuine case, the FIR was not registered. Then if she filed a complaint case before the magistrate in Bhubaneswar, my lord. And lordship may kindly see.
Where is that complaint?
Yes, lordship may kindly see. The complaint is at page 89.
Yes.
Lordship will see at page 91.
Now, on this complaint, the cognizance is taken.
My lord, what is important is Lordship will, if your Lordship looks at the complaint, there is also an allegation against the company.
No, we are at what stage?
Well, now cognizance has been taken.
You are on cognizance.
Yes.
Question.
And your Lordship, I have
The
not.
allegations are there, cognizance is taken.
There is no allegation. I'll explain to your Lordship that merely because somebody hurls an allegation against me, I would not be dragged to a offense.
Will be tested in the
No, that I'll cite a Supreme Court judgment to that extent, Malad. Merely because somebody hurls an allegation against me, accusation against me, I would not be dragged to face a criminal trial. That affects my liberty.
Trial will start after charge.
I'll come out here. This is a complaint case, Malad. What I'm saying is, Malad, once there is a complaint, and in the complaint, you'll also find the company is also an accused. Company is not accused in the complaint. The company has not been made an accused in the complaint. And
Who are you, by the way?
but we are not the employees of the company, Malad. Accused number one.
Dealer company.
Yeah, yes. Accused
Accused
number one, Malad, is the intending buyer. And these two accused persons are, Malad, the employees of Eicher. What the manufacturer, and Eicher is not made a party. Without the company being made a party, where the company said to have
nothing to do with the
yes, that is
business transaction. It is to the misbehavior.
no. First of all,
went to the showroom and asking for what happened to your booking and misbehave with that lady. The lady filed the complaint.
Who did it? It is only buyer.
That's
It's the buyer who did it, not I.
Yeah, all right, but what is the allegation?
Lordship may kindly see, Malad, the complaint.
Yes.
And it's a purely a Malad civil dispute regarding cancellation. It has been and also there has been an interim order passed by this honorable court with regard to another accused. Malad,
Who was that accused?
Malad, order there. I am handing over the order, Malad.
Is there any interim order?
Yes.
He is one of the
Yes,
George
yes.
is one of the accused.
One of the employees also. An accused here. Malad, let me just seize one.
Hello, I will have to pass this order.
Yes.
I will have to pass. There is no escape.
What order?
Give me.
Order.
And there are three accused. In case of one accused, this order is passed. I have to pass this order.
No, no.
Issue notice, tag with issue notice
Order there.
to the opposite party. Mr. Maharaja accept notice for opposite party number 1. Which notice tag with CRLMC number 3114 of 2022. It is asked appeal for the petitioner submits that there are 3 accused in this case. There are 3 accused.
No, there are 6, Malad.
There are six accused in this in the present case, initiated by the opposite party number 2. In the both 54, 55. One of the accused, namely Victor John Costa, alias Costa, approached this court seeking same relief. Same relief. The coordinate bench by order dated 3/11/2022 has been sent to
separate proceeding.
the parties. Pending the free to hand in the interim by way of interim order, the following order was passed. These following taking into consideration the following facts and circumstances, issue I am of the particular opinion that the petitioner is also entitled to similar relief as has been granted in favor of the co-accused. Accordingly, I so and so is allowed. And further proceeding in the so and so case. 54, 58.
Urgent copy, my lord.
Date. Yes. 56. Yes.
May it please, your lordship.
Say order ta
Item number 56, your lordship. The prayer is at page number 11. Your lordship may kindly have it.
What do you want?
Quashing of the NBW, so also the criminal proceeding. Similar order, your lordship passed last year, Friday.
What is this NBW as well as everything you bring in one petition?
My lord, what happened, my lord? The Friday matter, your lordship, that is in this matter, my lord, 420 kilo, 600 gram ganja apprehend from 3 number of accused, my lord. And based on the confession of one of the co-accused,
The same order, same order. If he is kept in a way, he will go and appear and speak and he will rely upon some judgment. Rely upon same order pass for change number of voters carefully. Yeah.
another CRLMC matter, my lord, that is a different one. In that matter, your lordship,
Which one?
CRLMC number 1485. The
Is it
two
listed?
listed, my lord.
Yes.
In that matter, your lordship, I am referring Satish Mehra, my lord, the Delhi administration.
You don't want this order. Same order.
Same order, but the fact is that, my lord, all the co-accused, front row accused are already released on bail and also they acquitted from the charges, my lord. And based on the confession,
They face
the trial, they face the trial.
Where is the judgment? Trial court judgment.
My lord, your lordship may kindly have it. Page number 18 to 26, my lord.
Yes. How many? What is what was their role and what your role?
They apprehend at the time of seizure, your lordship.
Spot apprehend.
Spot apprehend.
What about you? You ran away.
Ran away. The police cited me. I ran away, my lord. But my lord, my address is at Madhya Pradesh, your lordship.
From the spot you ran away.
The police said, my lord.
Escorting.
My lord.
That is allegation. What is the ground of equitable justice?
Your lordship may kindly have it. Page number 28, your lordship.
Come to page 21. In this case.
My lord. The independent witnesses such as PW3, 4 and 5 have stated nothing except admitting their signature on same paper. PW2, though the constable, he stated nothing about the alleged incident. In paragraph number 9, my lord, in view of the above discussion, decisions relied
Your
on...
case is at para 7. Yes.
My lord.
Main chief, whatever is the important thing you are not reading. Read it out.
Para 7 of the judgment, your lord.
Para 7, yes.
In this case, the brass seal was not produced in the court at the time of sending of the sample packet to chemical examiner. In a decision reported in 2022, Volume 1, OLR SC 565, the Honorable Supreme Court held that the recovery, seizure, and deposit of the contraband article having not been proved through the independent witness, no conviction will lie on the testimony of the police witness.
Yeah, Mr. Ragada. Yes, there is a finding that 50 is not complete.
That's true, my lord.
Then,
but in fact, he has not filed the charge sheet and no evidence copy, my lord. It is required, my lord. If it case will be passed, my lord. Otherwise, my lord, same order will pass.
50, see, finding is 50 is not complied.
My lord.
And if 50 is not complied, everything collapsed there.
My lord, that is another date. Even he may have supplied the evidence
I will
bring the immediately and put it on 19. It will be quashed. There is nothing.
Evidence copy, my lord.
Bring it. File it immediately.
Charge sheet and evidence.
Yes, second item. Para 7 also. First this push up and second. Para 7 also this.
My lord, your lordship is correct, my lord. But in fact, my lord, I have to verify the evidence copy.
Supply the additional immediately.
Around 19th.
On Monday.
19th.
19th will pass.
Grateful, man.
In 57, my lord, this is the petition for release of the vehicle implicated in the NDPS Act, my lord. And lordship earlier also heard this matter, my lord. And impugnment order is, that is page 19, para 2, my lord. Page 19, para 2. In that order, my lord, they have not entertained the present petitioner's petition, my lord, stating ground that only the prosecution and investigation agency is the empowered for
Today itself, in court, I have received the voluminous and adjourned on the 15th manner, 15th. In court manner, I
15th possible.
don't dispute on that.
What to do after
Ajit Elevate.
28th, it is jam packed.
One day,
It is 3 o'clock. We are not able to finish. जो होगा जो whichever is possible. See, that is the whole problem. Even if I accommodate, unnecessary matters are getting adjourned.
My lord.
And time is wasted. These matters are 5 minutes matter.
Yes, my lord.
But you don't supply copy, and he is also handicapped.
No, my lord, I have already supplied, my lord.
Noting that not petition copy.
They did.
Again. You supply.
Today I have received the
Again.
copy of the banner.
So hold on. 16th, last item maybe. Last item 16. Obliged, my lord.
Last item at 6 o'clock evening.
Item 58, my lord, I am appearing in VC, my lord.
Yes.
My lord, as it is noted that notice to the opposite party number 3 has not been duly served.
Yeah, notice of service. Have you filed the process and all?
Yes, my lord. My lord.
Urgent awaiting the service. No?
My lord, interim order was there earlier.
Continue.
Deep levelized, my lord.
My lord, sub item different matters.
Detect, so I can detect.
May I please? Here I have challenged the FIR and further proceeding. My lord may remember, last time it was my lord's contention because of the fact that on the eve of this Independence Day, some slogan was made. And taking note of this particular FIR allegation, the State Council, my lord, Mr. Maharaj has also, my lord, in a king style manner has said that it's just like Khalistan, all these things, my lord.
Yes.
In fact, and he has also taken, my lord, leave of the Honorable Court to get the up-to-date case diary, everything, my lord.
Is there more?
I have not completed. And taking into account all such things, it was my contention that sub-collector was there, other officers were there. And this thing has happened much after this particular slogan was over. Now, considering all such aspects, final report has been submitted. So the matter has become unprocessable. That's why, my lord, humble submission, whenever things will come up.
Final report.
Yes.
Protest. Here, what happened is even ABLAPL rejected by unsuitably rejected.
Final report, your
lordship found on the morning.
On the day,
164 statement there. In spite of that, the IO submitted final report. One case is
Mr.
And
Maharaj,
your lordship knows everything, Lord, how, what happening, and how this furious person.
because the fact that it was my contention, because the
can't
fact
say
that
that
the
he is
sub-collector,
innocent.
sub-collector, every
Only
other
because the
persons were
final-
there. In their presence, flag hoist was there. Subsequently, in the afternoon, these things has happened. So the particular informant.
Why to get into all this?
No, no,
Why
yes.
record it?
No,
exactly.
Let us depend by the.
Influxus for
Watching up.
ସେ ତ କେତେ ଜୋର ଚିତ୍କାର
ଓ
କଲେ।
ଖାଲି infectious ହବା ପାଇଁ ଏଇ କଥା କହୁଥିଲେ।
ହଁ କେତେ ଜୋର ଚିତ୍କାର କଲେ ସେଦିନ ତୁ।
ଦେଶରେ
On
you are for the
5.
state and any slogan against the state.
ଷ୍ଟେଟ୍ କେତେ ନୁହେଁ।
ଆଉ କଣ?
ପତାକା। ପାର୍ବତୀ ପତି ପାରକ।
And directed the state council to seek instruction regarding the status of the next. Mr. Kant, preparing for the petition subject. Meanwhile, the police has filed the final report in the instant case. Therefore,
Influxus.
Metric influxus, according to the petition of this poster.
Is your lordship. Lordship, I have a limited prayer, my lords, for speedy disposal of the proceedings, my lords. An FIR was lost in the year
And when was the affair?
It's in 2020.
Why speedy? Why you get
Well, it's in 20
superior attention?
No, not superior. I have some grievance, my lords. In 2021, the charge sheet was filed. In 18/5/2023, the charge was framed and then the trial has commenced. Only petitioner has been examined yet, my lords. The petitioner is in difficulty, my lords. He had taken a loan and paid 6,05,000 to the accused person to purchase a patch of land, my lords. Now, currently, he is jobless, my lords.
Have you filed specific performance?
No, my lords, we haven't filed, my lords.
Why?
There he hasn't. That's one more submission. There is another 138 proceeding is going in learned JMS city, my lords. She's evading there also. She's not coming here also. After the learned JMF, she had imposed a condition to be present on each and every day. Now, since last 2 days, she is coming, my lords. And there in the Raigada, her counsel is not being present, my lords. I just limited prayer, my lords. A time limit may be fixed, my lords.
Time limit 2012. How many witnesses? What?
Well, 8 witnesses are there. Only he has been examined.
You are PW1.
Yes.
Yes, Mr. Ravula, how much time?
6 months.
6 months. You.
And summons already issued, my lord. On 10/8/2023. 8 witnesses, 6 months.
Summons to witnesses.
Witnesses, my lord. Charge sheet witnesses. Order dated 10/8/2023. Accused absent but allowed to represent 317. Notable.
No, the limited prayer of the petitioner in this case is that the trial is unnecessarily prolonging. Therefore, there may be a direction for concluding the trial as possible. Then counsel for the petitioner pointed out the difficulties he is facing. Difficulty is facing because of the pendency of the present proceeding. He contends that the accused persons are not cooperating with the prosecution. That is the reason the prosecution is prolonging. There are as many as 8 witnesses cited in the charge sheet. Out of them, only one witness has been examined as yet. So the petitioner is appearing for the informant.
Yes, ma'am.
Petitioner is appearing for the informant. Next purpose. Petitioner is the informant in the case, sir.
Yes.
Petitioner is the informant in the case. Next purpose. The free fair speedy trial is a mandate, a constitutional mandate. Therefore, prayer made by the petitioner in the present matter deserves to be addressed. Accordingly, Mr. Ragada appears for the state and submits that since there are only 8 accused, one out of them, one accused, eight witnesses, eight witnesses. Out of them, one witness has already been examined. So ideally, the prosecution should conclude conclude maximum within a period of 6 months. Within a period of 6 months. Taking into consideration the statement made from the past by the parties. I have the considered view that the present petition is to be allowed with the direction to the trial court to do well to conclude the trial as expeditiously as possible, preferably within a period of 6 months.
Great.
6 months before the. Yes.
May I please, Your Lordship? My lord, this is with regard to release of vehicle. My lord, it is 7. My lord. My lord, the court says that this provision will have no application, though. My lord? Motorcycle, Your Lordship. And subject to what the State Council will say and subject to what Your Lordship will be pleased to hold. And there is also a decision on the point. May I just produce?
Which offense is this?
And this is under the NDPS Act.
NDPS.
My lord. And dealing with this NDPS Act provisions, this Honorable Court has been pleased to hold that 457 power has not been taken away. It can be
That's
exercised.
not taken away.
My lord.
What is the reasoning of the court below?
On that, Your Lordship will kindly find page 25. Page 25, paragraph 11. May I just place it with Your Lordship's kind permission? In the present case, the petitioner, who is the registered owner of the vehicle, has filed the application for interim release of the motorcycle. It is found that the petitioner also happens to be one of the accused in this case. He prima facie appears to have knowingly permitted motorcycle to be used for transportation of so-and-so in the pants pocket of his pillion rider. It appears that he has prima facie knowledge of keeping possession and transportation of contraband brown sugar dictated from pocket of the accused pillion rider. Here, the owner of the vehicle is arraigned as an accused directly for commission of offence under NDPS Act. Heavy burden lies on the accused petitioner to discharge the reverse burden in view of provisions contained in 35 and 54 of the NDPS Act. As such, the facts and circumstances of the case, it felt appropriate. One thing I beg to humbly point out to Your Lordship, the court below has proceeded as to whether a prima facie case is made out or not. So for a release of vehicle, that may be good for a bail application to consider whether the release should be. And here he has misdirected by considering the merit of the case as to whether, my lord. So far as the release of vehicle is concerned, it stands on a different concept altogether, which has been propounded by
the only thing is, it says the likelihood of confiscation.
That is there, my lord, but still then Your Lordships have been pleased to hold that it should not be, my lord, kept in those open spaces for and with adequate security. It has been released, and that is what, my lord, Your Lordship will kindly see here.
Yes,
it has,
I'll take instruction regarding confiscation proceeding matter. Mandate might given by.
It's already initiated or.
The age was there.
ନାଇଁ ମୁଁ at least କହୁଛି ଓକିଲଙ୍କଠୁ instruction ନେଇଥିଲି, but if my friend wants, he may take.
Only thing is you have to check the confiscation proceeding.
Here, my lord.
Then you.
If there is no confiscation, then
he will file indemnity bond and.
But it has been said here, I have no hesitation to hold that the operation of section 451 and 457 CRPC is not specifically excluded by section 51 of the Act. That is what has been held by this noble court, my lord. But I will only pray for a short date because I'm sorry that I couldn't move it earlier.
Short date means.
But this is the point.
I understand.
There will be no adjudication as such. So it's not a case where I
You have to seek instruction. You tell me. Confiscation is there or not?
I'll take it.
That much you can take telephone, and my friend is a astute.
Or shall I pass a preemptory order saying that subject to the confiscation proceeding, if any, release the vehicle.
sorry.
Better I will take instruction my lord.
Defer prior to hobani tenu se condition kar diyantu. Confiscation ethi kari paribeni. Trial पर से condition your lordship may impose. It's a conditional one.
No,
I don't-
subject to any confiscation proceeding.
Yes.
Release the vehicle with security and all.
Mal.
If you have provision, you do it, you know.
Man.
Finish. A motorcycle, what is it?
And my friend opposing doesn't sound good in the sense he has done so many.
He changed
But
side,
he's,
na? He changed
and he will be very soon coming back to this side also, unless he wants to continue.
Right on. The petitioner is assailing the order dated 16/5/2023, by which the learned court below has rejected his application under 457 CRPC. Interim, are stating that since the act contemplates confiscation proceeding, and since there is a likelihood of confiscation proceeding, therefore the vehicle cannot be released. Mr. Mishra appearing for the petitioner submits that the application under 457 is not barred under the Act. Therefore, the reasoning given by the court below in rejecting the application is misconceived. Taking into consideration, Mr. Ragana appears for the state and opposes the application. Taking into consideration the facts and circumstances of the case, I am of the view that the application number 457 CRPC moved by the petitioner is deserves merit and same should have been allowed. Accordingly, the application according the vehicle, namely motorcycle vehicle, is directed to be released by the court below, subject to petitioner furnishing security bond.
Property
Security, what valuation would show it?
Valuation will be very less, your lordship.
Subject to petitioner furnishing security and indemnity bond. Indemnity bond. Before the trial court may get a valuation report, and accordingly accept the security to be permitted by the petitioner. Therefore, we say directly is subject to any confiscation proceeding. Any pending consideration, if any.
Pending, my lord. It will come up.
Not pending. Confiscation is not there.
If any confiscation proceeding initiated in the meantime, the order shall not be given effect to.
Subject to confiscation proceeding, if any. Subject to confiscation proceeding, if any.
And they think, my lord, they both need to oppose me. So therefore, both are also expert in the field. That is another problem.
The problem is if heavyweight comes, the two.
In fact, sitting on the backside, I was just about to inquire from them what is the position of law.
And he is also heavyweight, another heavyweight. To balance both of them, oppose. What to do?
He is otherwise also our decision maker, the bar council member, and decides our fate also.
Disciplinary authority.
So we are afraid of him.
Naturally. Yes. Yes.
My lord, I have already removed defect number 3. Now there is another defect.
You cure it.
By day after.
List it.
By one day or a day after tomorrow, I will.
Let us see.
Yes, the matter makes okay.
Again.
66.
My lord, the requisition already filed, my lord.
65.
Requisition already filed.
What filed?
The requisites, my lord. So, OP number 2, my lord.
Let's see, awaiting service. No, urgent. Awaiting service urgent. Yes. Next.
66. 67.
Wait, please, your lordship. Your lordship,
Milord,
the petitioner.
65 was there, Milord. I am in 65, Milord.
Urgent. Yeah.
It is urgent, nobody appeared, Mr. Mishra.
Milord, 65 was. I was. I was there. I am there and still I have logged in since 2 o'clock.
We couldn't see what is this matter is about. 1 minute.
Milord, matters, Milord,
Because
the.
if it is a lengthy matter, I can't hear it. Because
No, Milord. Milord, that is a small matter. Milord, the
I
London.
think OPID matter, but perhaps OPID
No, not. It is not OPID matter. The court has dealt the 457 matter. So DCS has assigned the OPID court to deal a 457 division. That is not OPID matter. That is not OPID matter. Milord, it is a revision challenging the Milord rejection of Milord release of articles which was seized in course of investigation. The revision was preferred. Revision was Milord partly allowed. Revision was partly allowed for release of a gun, revolver, Milord. Though, Milord, the order is misconceived because the London Milord Revisional Court.
Who are you?
Milord, I am the owner of the revolver gun.
You are accused.
I have subsequently made an accused, Milord.
But whatever, you accused only.
Yes. That is there. That is there.
Your gun is released now. What is the
gun is not released, Milord. Gun is not. The document is released. For purpose of Milord renewal, I have got the documents. The revisional court released the document, but without application of mine, Milord. My sole limited point is that.
So if it is released, if the documents are released for renewal, you get it renewed.
No, Milord, my contention that my gun is not released only because that it is the MO. It will be subject to material object in trial. Any day it will be produced. That is the only sole ground of rejection, none other ground.
But in any case, you have to get it first renewed. Who knows your renewal application will be rejected.
So my
get it renewed first.
Yes, Milord, that is there. But instead of Milord the original.
If your renewal application is rejected, then gun will not be released to you.
Without production of the original this gun, they will not release
If they demand that, then you can verify the order. You can move an application.
So then,
I'll observe that and dispose it up.
Your Lordship may observe that the renewal and so far the preservation of the gun, because dust and all that, if you not taken in care, it will be deteriorated. And Milord, the release of 457, they have resolved this entity. The London Divisional Court has not touched the point. Only they have rejected. They are not releasing gun. That it will be subject to production.
Have you applied for the renewal?
I will take instructions. That part I have not done.
You are first. Tell me whether you have.
Will Lordship, yes, I will. Will Lord skip it to next week? I will opt in with the instruction.
Next.
67.
Wait, please, your lordship. My lords, the petitioner has approached this honorable court for quashing of the cognizance order dated 31/12/2022 for offences under section 498A.
Okay, what is the?
Yes, my lord, the petitioner number 1 is the husband of opposite party number 2, and the other petitioners are the male members of the family. They are the in-laws. So, my lord, initially the police did not, the Kharbel.
No female members are there.
No female members are there. And my lord, initially the police did not register the FIR. Thereafter, on complaint before the London magistrate, in compliance of the order dated 3/3/2022, in complaint case number 1164 of 2022, the Kharbel Nagar police station registered the FIR 88 of 2022 on 18/3/2022. So, my lords, my humble submission is that in complaint, the opposite party number 2 has categorically stated that the marriage was held on 18/8/2021 in Arya Samaj Mandir, Hyderabad. And after being severely tortured, she came back to Hyderabad on 25/9/2021. After marriage, they went to Mumbai. She lived there for a month, and she was being brutally tortured. And thereafter, on 25/9/2021, she came back to Hyderabad. This has been mentioned in her complaint. But my lords, may I kindly see annexure 9, page 53.
9, huh?
Yes, my lords. Page 53. This is the letter which is sent to the husband as well as all in-laws
Yeah.
by the wife. I have annexed the
Why
copy.
mean that opposite party number 2?
Yes, your lordship. Yes, your lordship. It is duly signed by her.
As you know earlier.
Yes, my lord. As you know earlier, you and I have married on 18/8/2021, and the marriage solemnized took place at R.S. Samaj, Lakshmi Sagar, Hyderabad. For your more information, I am sending you a certified true copy of the marriage of certificate and a photograph of the wedding.
She is only reminding that you have married.
Yes, my lords. And the most important part, that is in the third para, we stayed very happily when you left. Why you left me? And this letter, my lord, I have also.
So you are emphasizing we stayed very happily.
Yes, your lordship. And this letter was sent on 21/12/2021.
Your entire defense is on this word.
No, not only this one. There are several things.
So cognizance order has to be quashed because in a letter happily what is there? That is your thing.
No, not that is it. It's a honey trap case, my lords. My lord, I have also annexed several documents. It's a honey trap case.
Every marriage is a honey trap case. What?
No. This one is, my lord, specifically annexure 4, my lord, may kindly see.
Investigation is going on, and he has stated, she has stated, I cannot bear mental harassment. I am staying lonely and feeling very depressed
Yes.
due to the continuous mental harassment and depression. I cannot take care of myself. So,
She is not reliable.
Entire paragraph. I am relying upon in the entire
She
paragraph.
is not relying upon the further. Only the first line she is relying.
No, my lords. I am entirely depending upon the entire paragraph.
The investigation.
No, she has categorically stated that she was brutally tortured, मार दिया, पीट दिया, ये कर दिया, वो कर दिया. यहाँ लिख रही है mental harassment हुआ है. Because she is staying lonely.
These are at the realm of investigation.
No, I do agree with your lordship, but my
I pray your lordship can take it next week because of this is a
Next
check
week,
box.
how many matter one court can take?
For a moment, your lordship, the petitioner is accused.
Then if it was so important, you should have done it.
Just in the
What to do?
notification, I
What
find
to do? You try. Humanly not possible.
any day.
How much a judge can do?
Yes,
Only limited matter we can do, na? But we will see where we can. So, Jyoti, देखिए
138 matter.
यही period दिखाओ.
Next.
If matter is listed, then you should come with
Just
one day you will
found
take
that
for
notification. That's why.
then whatever he will give it. Yes, next.
Any date next week, your lordship.
Next.
Deep replies.
देखिए देवे कोर्ट compromise. Last 80. Let us see where we are in. No, continue. देखिए, I'll take after 10. Let us see how many matter we can finish up.
Yes.
69.
May I please, your lordship?
Yes.
Here in the present case, my lord, the petitioner is the mother-in-law, and so far allegations are concerned, my lord, lordship kindly have a glance. That is page 18 is the FIR, my lord.
This is the arising out of
498, my lord. 498 506, my lord.
where is informant? You have not implemented.
My lord, I have already brought, my lord.
But you implemented.
Yes, I have already that implemented. Lordship, just my on oral prayer, lordship, kindly accept this, my lord. I have made her as opposite but not 2.
Tell me what is your.
My lord, also I am giving this, my lord, that sister-in-law's application has already been allowed by this honorable court.
Sure.
Their informant did not appear, my lord. Though notice is served, my lord, but she did not appear, my lord.
Sister-in-law.
My lord, sister-in-law.
Cognizance order challenge.
My lord, proceeding is under challenge, my lord.
Let counsel for the petitioner. In this petitioner has challenged the criminal prosecution launched against him by the first the petitioner seeks leave of this court to implead the informant as opposite party number 2. The permission is granted and opposite party number 2, informant is impleaded as opposite party number 2. Amendment party is taken on record. Okay. In this petition, petitioner is challenging the seeking quashing of the criminal prosecution lodged against her or him, lost against mother-in-law.
My lord, mother-in-law.
Lost against
Widow mother-in-law, my lord.
law against her at the instance of opposite party number 2. The petitioner is the mother-in-law of opposite party number 2. The petitioner submits that insofar as the sister-in-law of the opposite party number 2 is concerned, she has filed a separate proceeding, being CRLMC number 3584 of 2022. The coordinate bench of this court, by the order dated 4/9/2023, has been allowed the petition and quashed the entire proceeding. He strongly relies upon the said order of the coordinate bench. Coordinate bench. The number okay. Issue notice to opposite party number 2, retainable within 4 weeks. In the meantime, proceeding before so and so. Stay. Mr. Maharaj appears.
My lordship, I'm challenging the cognizance, my lord. Here the case 419420, my lord. The both.
Metro lengthy metro I told you to wait. Lengthy metro. Lengthy metro, every metro hearing takes place. You will find out. So a balancing. But from tomorrow onwards, take it up. Don't reach many lengthy matters. Can't be possible. Lengthy matter can't be possible. And dissatisfactory hearing, what is the use? Yes. Neither you are satisfied nor I am satisfied. That's not the idea of. Yes. Yes.
My lordship. My lord, this is under 419/419/420, my lord. Challenging cognizance in this case, my lord, both the parties, petitioners and OP number 2 are ready to settle the case.
Bring them, finish it up.
So, my lord, kindly issue notice to the OP number 2.
Okay.
That's
Counsel for the petitioner seeks quashing of the criminal prosecution launched by opposite party number 2 against him. He submits that petitioners, he submits, the counsel for the petitioner submits that they have settled the dispute. Issue notice to opposite party number 2. Retainable. Mark the
71.
You will not ask for stay. You have settled, then you have to ask for stay. If it will be aggravated, then the settlement will be unnecessary.
and just to issue notices.
Very good.
Satisfied. May I please, madam? Here I have filed this application, assailing the order of the Land and Trial Court, wherein he has rejected my application under 311 CRPC.
He did not appreciate what I am saying.
Let us take or
Let us stay. You
Yes,
will
sir.
not answer.
Janipam.
Give it to him. Okay. You tell him. You should ask for stay because you have settled. Otherwise, what happens is if proceeding will take place, the settlement is your opponent will be wiser. Stay. Okay. Stay. Yes.
My lord, here I have challenged the order of the Land and Court below, dated 16/11/2023, wherein he has rejected my application under section 311 CRPC, my lord, to recall PW 5 and 7. Offense POSCO Act, along with my lord, 376 511 attempt and 3 of the SC Act.
7 PW?
PW 5 and 7. PW 5 is the doctor who has not at all been cross-examined. Not a single question has been put to her.
Doctor?
No, doctor.
Okay.
And so far, PW 7 is the concern. She is the mother of the victim, who is also turned hostile. Last time, I directed him to.
Where are their statements?
My lord.
Where are the statements?
filed it earlier.
Statement are not there.
I have filed, man. Earlier I have filed.
ନା ନା କପି ନାହିଁ ଆମ ପାଖରେ
ମୋ ପାଖରେ ତ ଥାଏ ସବୁ
କପି ଗୋଟେ
ରଖୁନି କିଛି।
କିଛି ନାହିଁ ଆପଣ ଦେଖନ୍ତୁ କିଛି ନାହିଁ।
5 and 7 madam.
Huh?
କିଛି କପି ଦେଇନାହାନ୍ତି
Not there.
Madam,
ଆମ ଗୋଟେ
ନେଇଯା ନେଇଯା 5 court has himself in the order sheet has mentioned that the PW 5 has not been cross-examined and PW 7 also madam.
କାହିଁ କଲେନି ସେଟା ଦେଖିବ।
And yes, I have taken the ground that the concerned senior counsel, because of his ill health, he had been outside, and that is the reason for which and he had been operated.
PW7 na?
Yes, PW 7 hochi hostel he jaichi mother. And last time I started me to examine and to apply this honorable court that whether a hostel witness can also be recalled. I have got a judgment of the although of not this honorable court, Punjab and Haryana High Court.
ଆପଣ ଏଇଟା ଏ PW7 ତ ଦେଖୁନାହାନ୍ତି ତ କିଛି ନାହିଁ ତ PW7।
PW 7 or not. Madam, let me see the order also. Order sheet also speaks.
So, at least
Madam.
PW7, you say that they were not cross-examination. Where is that? ଏଇଟା ଯୋଉ ଦେଲେ ଆପଣ
Madam.
ଏଥିରେ ବି ନାହିଁ PW7।
In the said petition, it is mentioned that PW 5 being the I have also being the medical officer who examined the victim was discharged only after being given a suggestion in her cross-examination, and similarly PW 7 being the mother of the victim who was examined on such and such date was declined for cross-examination by the defense counsel. That is borne out.
Where is your 300?
Mal, that is also I filed.
Page
That
9
is
your lordship.
page 5. Page 5 na? Page 5 is my petition.
Propose question वगैरह କିଛି
इसमें କିଛି ପଚରା ହେଇନି के?
କାଇଁ ପଚରା
କିଛି ପଚରା ହେଇଥିଲେ ହେଇଥାନ୍ତା। କିଛି ପଚରା ହେଇଥିଲେ
Page
ହେଇଥାନ୍ତା।
9 your lordship relevant. This is a case where these two witnesses have already been not supporting the prosecution case. They have been hostile. As has been again ସେଇ ଦିନ ସବୁ discuss ହେଲା long lengthy argument made by my senior, and he has to satisfy now whether a hostile witness can be recalled.
Well,
and he will file the decision of the Supreme Court. So now this decision is not applicable at all.
How can you insist me to judge cite a decision of the apex court? A decision.
Decision of which court?
Punjab.
मते सब document दियंतु मो verify करछि to contest to that. How can this witness will be recalled in the case of POSCO?
As per direction of the Honorable Court, my lord, on dated 17 January 2024, my lord has directed to file a joint affidavit. My lord, today the opposite partner appear କରୁଛନ୍ତି ଆଜି।
Joint filing.
ନାଇଁ ଆଜି କରୁଛନ୍ତି।
Dispute has already been settled.
Offense କଣ?
498 case, my lord.
Are they appearing?
My lord, opposite party.
I am appealing.
The girl is appearing?
No, informative. Sir.
Today they have not come.
କେବେ ଆଣିବି?
Who date को तो?
नहीं, ओटे 15 दिन पर
After 15 days.
The notice was issued by this court on in the last date of hearing.
Notice not requisite not they so much appeared. Not a
notice was issued by this court in the last date of hearing. Okay. Hearing, full stop. Mr. So-and-so entered appearance on behalf of opposite party number 2. The parties conjointly request for a date to enable them to file the joint affidavit and to and for appearance of the parties to the
yes. My imprimatur sir continue. My lord. My earlier imprimatur is there.
Imprimatur to continue.
Okay.
74.
Challenging order 19/4/2023, but the plaint of the petition 74
What do you
rejected the petition of the complaint case of the petitioner, where it is stated that no steps have been taken by the petitioner. He has engaged.
Kali kitna matter? Huh? Kali remaining matters Kali by. This matter tomorrow,
Yes.
the remaining matter, only I'll take item 80.
Yes, yes.
Okay.
All the other matter, it will be spill over to tomorrow.
76, I seek the Lordship's permission to make a mention. Item 76, the stay is still today. So,
Tomorrow I'll take, how will?
Kali actually problem my death anniversary of my father-in-law. So,
76 urgent, interim order.
76 urgent.
till next day,
76
interim order to continue.
बाकी सब वो नहीं है।
I'm
80.
Opposite party number 3.
Thank you.